What is urgency?
My lord, election matter.
Election, what is urgency?
Urgency is this, my lord. Now, Chief Electoral Officer has issued an order that the counting supervisor will be also from the central government and PSU. My lord, firstly, Chief Electoral Officer has no jurisdiction. This is not done in any states, only in this state. And why this? The government means the government under section. It has been said. What is a government? Government means read with Article 12 and etc. Here is the appropriate government is
The
state government. And all state, all you are taking all state officers, and in the counting that is a central government. Why? And this has been a circular was issued long back, and it has been circulated only on yesterday. No, it has been moved today, my lord. Any time your lordship gives it, my lord.
2 बजे फिक्स है ठीक है 2 बजे supplementary list at 2 p.m. supplementary inform the issue notice.
I will start the copy. Can you take it? This I have deeply obliged to lord.
I have a similar prayer minute to move the matter at 2 p.m. It's the election matter minute. So the counting place where counting was scheduled, it was not informed in terms of Rule 51. They are proposing to change it to a different place without any notice to anyone, contrary to Rule 51. I shall try to persuade your lordship, may I have leave, I shall serve and come back.
But I don't want to move it today. It's neither an election matter, not want to move it today. But my contract has been neither election matter nor moving today. My contract has been terminated without issuing any notice, not without any show cause. Allow me to move it on 5th, my lord, so that I can come back. 5th, my lord, within 5 or 10 matters, my lord.
5th को कर दो within 5 minutes.
Maybe
mention a matter WCA 3763/2026. An petitioner is an octogenarian woman. He has grievances over West Bengal Housing Board. In spite of following all the regulations, West Bengal Housing Board assured him that they will issue him a plan, but they are not doing the same. Praying for inclusion in the list, my lord.
When the agreement was entered.
My lord,
when the agreement was entered.
My lord, it was entered around 2000.
And when you file the writ application.
My lord, it is in your court. I don't remember when I filed the petition. Your court, my lord.
Which number?
The number is WPH.
Now, whether it is not in the list.
Last it was listed 9th of April 2026.
So you have not checked the monthly list.
Monthly list hasn't come, my lord. It was in daily list. 9th of April.
Monthly list of April you have not checked.
My lord, it was not in monthly list. Then it was given into the daily list. And last it was on daily list on 9th of April 2026.
Might be so you have taken step on, you not taken step on. Yes.
Then it was delisted.
Yes, that's why you not appeared. So it has gone out.
No order has been passed yet. It has not been read. Stage the new motion.
Okay, new motion.
So this is also an election SIR matter, lordship. This is also an election matter, lordship.
What is the election matter?
Lordship, I am praying for only as early disposal for this application.
Election matter.
Lordship, urgency is that, lordship, my name is deleted. I apply for an appeal. Yes. But my interview has been completed on 10 February. Now I will be admission for PhD, lordship. But I will be admission for PhD course, lordship. But there is need to domicile certificate. And that certificate has not been issued because due to my name has been deleted.
Okay. So when the last date for the PhD?
Well, next month maybe admission will be continued, lordship. My interview has been completed.
Okay, you let
today 2 p.m. also an SIR matter.
Lord, let the matter appear on 7th May within 10 matters.
2 matters, lordship.
Restoration application.
Give.
Yes. Permitted, your lordship. My lord was pleased to pass an order on 28th, my lord. However, there is some certain my lord typographical error which is required to be rectified, your lordship.
Give all the mentioning list. Give to my court officer.
My lord, item 268 of today's list. My lord, the interim order is expiring on 5th of May.
5th of May, you come on 5th of May.
My lord, the matter is appearing in the list under
you
hearing.
Come on 5th of May if the matter is taken. Otherwise, at the time of rising, you mention it. I will take the matter.
May I have my lord's leave to mention a matter? This is challenging a tender process evaluation. The matter has already been filed. We would crave my lord's leave to file it on the next month's monthly list. I would request my lord's leave to file it in the next month's, to have it appear on next month's monthly list, my lord.
Okay, give the list. I will. Yes, call the list.
One for judgment.
CRR disposed of. Next.
2, 3, 4, and for the petition.
All writ petition dismissed.
Grateful to you.
Can is dismissed. Consequently, WPA is also dismissed. भिजवा दो. Who is there? Nobody is here. As the matter is listed today for to be mentioned, but when the matter is called, none appears on behalf of either of the parties. This court find that the matter is already disposed of. Let the matter be deleted from the list of this court. Next.
Lordship, I'm led by Mr. Mukherjee in this matter, Lordship. Lordship, I'm seeking passover for 5 minutes, Lordship. He's just coming. He's in court number
Passover.
5. Much
Next.
obliged.
आज का रेजोल्यूशन है चिन्ह ना. Though the matter is listed as urgent motion on the prayer made by the counsel for the parties, but the matter is called today, none appears on behalf of either of the parties. No accommodation is sought for. Let the matter appear in the combined monthly list of July 2026.
Lordship, we are there for the petitioner.
Yes. Yes. What is the matter?
Lordship, it is a matter related to premature release. I'm in custody for a period of 22 years now, Lordship. I was
When the FIR was initiated.
Lordship, it was on 29/02/2004, Lordship.
2004 case was initiated.
The case was initiated.
What is the section?
Lordship, one more thing I want to bring to your notice. On the 66th meeting, Lordship, I have marked the page, Lordship. 50.
50.
50.
Kalo Khan.
Kalo Khan, Lordship. Lordship, I have been recommended to be released by all the concerned authorities. And Lordship, this meeting was held on 5/8/2021.
After that, nothing.
Nothing, Lordship.
In this, there is no decision is taken.
Lordship, the release cum remission order is not being issued, Lordship.
That's why this meeting, this is of the 66th meeting of the SRV.
Right,
Correct.
Lordship.
On 5th of August 2021. You have a notification. There is a notification because if the authority state sentence review committee is taken it, then the government has to take a decision within 4 months or 1 month, 30 days something is there. You are not having
that notification.
not having that notification.
No, Lordship.
Circular, circular.
Lordship, I don't have that notification, Lordship.
I have disposed of one matter on that ground.
Lordship, I'm in custody, I'm suffering. I've applied for a fresh detention also. And then, Lordship, because we are doing a lot of other premature release matters in all the courts, Lordship. In one of them, where I was served a copy, Lordship, I have received this. And he has been recommended. He's languishing behind bars for 5 years, even after being recommended, Lordship, by the board.
So So that's why now the state is not that, let the state take its instruction, whether this has been
Affidavit of
decided or
service,
not.
Lordship, we are, and state also, Lordship, time and again, we are informing
why-
the authorities.
But the problem is that if I pass an order, tomorrow you will find that this already they have taken the decision, not been communicated.
Lordship, whatever
Nothing.
you deem fit, Lordship. Actually, Lordship, we are again and again calling the other side. We are informing even the department that Lordship is overburdened. Once the matters are coming, please appear. Please appear, Lordship. Time and again, they are not appearing, Lordship. Even for the other premature release matters, Lordship.
The petitioner has filed the present date application praying for premature release on the ground that the petitioner is in correctional home since
24 to 29 to 2004, Lordship.
29th February 2009. 9. Full stop. Counsel for the petitioner.
2004, Lordship.
2004. Full stop. Counsel for the petitioner submit that just the petitioner has got the proceedings of the 66th meeting of the State Center Review Board, West Bengal, held on 5th of August 2021, wherein at serial number 50, the case of the petitioner was considered and for recommendation, considered and recommended for premature release. And counsel for the petition submit that though the state sentence review board has recommended the case of the petitioner for premature release in the year on 5th of August 2021, but till date the government of West Bengal has not taken any decision with regard to the recommendation of the state sentence review board West Bengal held on 5th of August 2021. As none appears on behalf of the state authorities in spite of service of notice, but this could find that one opportunity is to be given to bring on record whether the government of West Bengal has taken any decision with regard to the recommendation made by the State Sentence Review Board West Bengal on 5th of August 2021 with regard to the premature release of the petitioner. Full stop. Let the report be filed within by 8th of May and by 7th of May 2026. The petitioner is directed to communicate this order to the government pleader, who is appearing, or a public prosecutor who is appearing in the matter.
Lordship, no idea. We just know the name.
To the government pleader as well as to the state authorities, along with this order and to file the affidavit of service on the next date fix. Release the matter on 7th May under the same heading, same position.
Grateful, Your Lordship.
Madam, I'm grateful for your Lordship's indulgence in this matter. I am a trader, my lord. My bank account has been, initially there was a complaint by the National Cyber Authority leading to a certain sum of money, 8,000, 9,000. Initially that sum was lien. But subsequently the bank freezes my whole account without any rhyme or reason. Page 17, they communicate to me that due to some mismatch in transaction pattern, they freeze my whole account. Now, Lordship knows that whereas various guidelines of the Honorable Court and various other courts which says that the disputed amount can be lien. But my whole bank transaction cannot be stalled only at the
when it was freezed.
Lordship will see page number 17, they have sent me an email, page number 17, on 2nd of April 2026, they sent me an email saying that we have noticed some recent activity on your account that does not match some unusual transaction pattern. As a part of commitment to safe, responsible banking, we have temporarily restricted detailed transaction of your banking account. We write to them, there's a detailed letter written to them by me on 6th of April, 7th of April, no response from the bank, and my banking transactions are completely restricted. I am a trader, I deal in mobile.
It is a saving account or current account?
Current account, my business account.
Business account.
And that's my only business account, and Lordship will see on the previous page, page number 16, there was some dispute leading to a particular transaction, but where 9,975 was said that this amount is a disputed account, and National Cybercrime Portal reported something to the bank. But they lent this amount. But if there is an investigation going on in this amount, I don't have a problem. But my whole bank account is debit freeze, right now.
Yes.
My lord, I am for the Union of India, my lord.
But Lordship is, may I just
Who is for the bank?
And
Have you served?
These authorities.
Have you served? Where is your
I have
affidavit?
served, just give me, I have served in course of the day, possibly.
That is the problem. You all persons are mentioning the matter. When the matter is listed, then you are not coming with the affidavit of service. Tomorrow I will pass an order. They will go with this order without hearing. Court has passed an order. If you are having urgency, why you are not serving the copy bank?
We have served video. Lordship, be kind enough to keep it at 12:30 or 2 p.m. I have the affidavit of service. Only thing is due to some exigencies, the advocate on record is yet. Being subject to correction in these authorities, the courts have held that the whole bank account.
Yes, what is your instruction?
My instruction is the Indian crime coordination system is an organization which is a platform to complain any this type of crime, my lord.
Can you freeze the account?
The bank cannot freeze that.
Bank freeze the account. Show me the law.
My lord, I want to file the affidavit, my lord.
No, you show the law. You are telling that bank can freeze the account on your submission. I am asking, calling upon you to show the.
I'm for the Union of India, my lord.
So without knowledge, why you are telling that before the court the bank can?
I'm not representing bank, my lord.
Please go through the law, then you make a submission. Once your clients, the persons are not going to your bank, your persons are coming to the house and of the shop of the traders and all these things, open the account. When the bank open the account, then you persons are telling that you can freeze the account.
No, I'm not representing bank.
Yes, where is there is no affidavit of service. What can be done?
We'll keep it at 12 p.m.
No, 12 p.m. other matters are there.
It has been served, but I produce that. I'm grateful.
Regarding freezing of account, my lord.
Yes, next. None appears. Though as per the mentioning made by the learned counsel for the petitioner, the matter is listed as urgent motion. As urgent motion. So why you are not coming? Yes.
My senior is on the virtual.
Yes, what is the matter?
The matter is the petitioner is the owner of the premises number 1/1 Durgacharan Dr. Lane. And the premises was purchased the premises with various tenants. One of the tenant is situated in the ground floor. He is running a confectionery bakery business. This is Dahlia Bakery from that room. Without any and have installed iron grill, bakery equipment, chulas, and etc.
There is the affidavit of service.
Lordship, it is not affirmed, but already delivered.
How the court can go to the without affirmation?
Lordship, actually, argues to the plea. That's
not today.
Lordship, kindly. The legal
Next.
to make.
And I am for the
keep them
respond of
at
five.
the
Yes.
same place, Lordship.
You lost your chance. You persons are not coming with all the.
Lordship, within course of the day, I will.
So. Yes.
Please, my lord. I am for the petitioner, my lord. My lord, am I audible, my lord? I'm sorry. My lord, am I audible, my lord?
Yes.
My lord, with your lordship's leave, I am appearing online. But it's a very short issue, my lord. Freezing of bank account without due process of law. My lord, this, my lord, I am covered by your lordship's judgment that under BNSS, my lord, in order to, my lord, freeze a bank account, my lord, the police has to follow the, rather, my lord, the bank has to follow the procedure as envisaged under section 107, which was not done in this case, admittedly. My lord, the extensive argument was made by Mr. Mojumdar, my lord, then, my lord, your lordship's pleasure was, my lord, with a order, my lord, of February 2026 that we should add, my lord, Ministry of Home Affairs a party, my lord, that we have made.
Yes.
My lord, we are relying on a judgment of your lordship, my lord. My lord, my junior will hand over. I think, my lord, that judgment was not handed over when Mr. Mojumdar argued. He relied on all other judgments of my lord. Now, my lord, this Sanjay Gupta versus State of West Bengal, my lord, this is absolutely clear on this proposition, my lord. That this cannot be done, my lord, without there being, my lord, any compliance of section 107. There is no 107, my lord, under CRPC. Now, under, my lord, BNSS, there is a detailed fasciculus provided under 107, which requires, my lord, a notice to be given. Then, my lord, there is a hearing, and everything has to be done, my lord, under the my lord, order and jurisdiction of a magistrate. So unless there is a magisterial order, my lord, no bank account can be frozen. My lord, para 8 onwards, if I may draw your lordship's attention to, my lord.
Yes.
My lord, I'm covered by this judgment, my lord. Here in this case, my lord, there are 5 companies, 5, my lord, current accounts were frozen without following, my lord, the due process, and which is absolutely contrary to the law laid down by your lordship's
The
court.
bank.
I'm appealing on behalf of the.
Yes. What is the contention?
Well, I freeze that account in terms of the action passed by the authority. But, personally, I do not have anything to submit before the lordship. My lord, if your lordship directs so, I can unfreeze that account.
And I'm for the respondent number 5, my lord. Will kindly give me a week's time to file a report, my lord. My lord, showing this case has been taken. But I was added as a party only on the last occasion, my lord. You. But I'm the Union of India, my lord. What you will say? But I can demonstrate before your lordship the steps taken by me, pursuant to which I've given instructions to the bank to freeze the account.
No, it has to be by the magistrate. I'm sorry.
We have to place before this court whether you have directed the bank to freeze the account. Correct. Whatever it is, your investigation, whatever it is. Have you obtained any order from any of the magistrate or where the jurisdiction magistrate for freezing of the account? I had given an email for instructions. When you receive the notice. But I've given an email for instructions. But it will kindly give me till Monday. I am giving in writing. Your instruction will not come. They are in several other cases. Notice has been served. Investigating authority never appearing before this court. First time I find that you are appearing for the investigating authority. You are appearing for whom? For the Union of India. Union of India. What the Union of India will do, sir? That has been.
My lord, the Union of India subject to correction, my lord, is a formal party.
Yes.
And my lord, the
nothing to do.
right, my lord. And there is
whether you are appearing. It is at least the petitioner's allegation that it is on my instruction that the bank has that is the petitioner's instructions at least till Monday, my lord. I was humbly praying I'll try to seek instruction. Come Monday. Learned Council appearing for the Union of India prays for time. Accordingly, for the interest for taking instruction, according case adjourned, let the matter appear Monday under the same heading, on the same position.
My lord, may I just request one thing, my lord, if your lordship permits me. My lord, Monday, obviously there will be a resolution, my lord. Kindly have it on Tuesday. Otherwise, they will take time, my lord.
Tuesday.
Most of us.
Deeply.
I beg to appear for the petitioner, my lord. I am a company, my lord. My deputy, who I had entrusted to enter into a sand mining lease, my lord. This is my affidavit of service, my lord. My deputy, who was given my authority to enter into a sand mining lease, had obtained the lease in 2016-17, my lord. Thereafter, your lordship knows in 2021, certain regulations came which required further extension by way of proper execution of lease, my lord. My lord, what had happened in the meantime, my lord, he went astray, my lord. There were some internal disputes. He was taking every burden on himself, my lord, keeping outside, even though all the payments were made to the department by me only. I have also annexed the bank accounts. Before delving any further, my lord, the only difficulty, the order. Basically, after this 2021 notification, I filed a suit against this person, my lord, the respondent number 9, and I've obtained an order of injunction that pertaining to that piece of land, that piece of mining land, no action should be taken, my lord. This I communicate to through my demand letter through the concerned department, my lord. The only difficulty is that, my lord, even after obtaining the injunction, my lord, the department has issued a notice to a letter to him inviting him to execute a long-term lease. I am saying, my lord, without me in picture, my deputy who has gone astray and against whom I've already obtained an order of injunction, that particular extension cannot be executed by the government. My lord, that notice is at page number 49, my lord. But the only difficulty in this writ petition, my lord, it's our error, my lord. In page number 49, your lordship will find that notice, my lord, 24th November 2025. Lordship will find this is given to Sri Pramod Kumar. Pramod Kumar is the respondent number 9, my lord. And just prior to that, my lord, page number 48 is the order of injunction, my lord. Filed the suit. The trial court refused. I appealed. In the appeal court, I got the injunction, my lord. Page number 48 is the injunction. But, my lord, in my mistake, my lord, everywhere in my writ petition, I have mentioned 24/11/2025 as 14/11/2025, my lord. And even in my prayer, my lord, which is very vital, I've mentioned that
14, what is, what?
the page number 49, my lord, that is the letter that I'm challenging, my lord.
24/11.
Yes, that is the date is 24/11. But throughout my writ petition, my lord, inadvertent error, my lord, 14/11/2025. My lord,
so what you have prayed for? Now
I
you
have
got
prayed-
the
I have- I have
now you
prayed-
got the interim order from the civil suit.
No, I have got the interim order from the civil suit, which does not bind the state respondents, my lord. It's a suit against the private respondent. The order is communicated to the private.
Where is the order?
Yes, my lord. The order is at page 48, my lord. It starts from page 47. Your lordship will kindly take at page 47 P7.
That is the civil court order.
That is the civil court order, my lord.
Where
And
is
then the-
which order you challenge here?
Page 48, my lord. 49, sorry, my lord. 49. Your lordship will see, my lord, please enclosed here with the notification under page 49, my lord. Page 49.
Yes.
Page 49. Kindly see the date is 24/11/2025. It is
Correct.
addressed to Pramod Kumar. Pramod Kumar is the person against whom I've obtained the injunction. He's the private respondent, my deputy who has gone astray. My lord, the next page is not.
So how you are connected with the private respondent?
Well, the private respondent is my person, my lord. When we initially made the initial payments in 2016, my lord, I'll just indicate the letter of award, my lord. The award which was given to me for the mining, my lord, it is at page number 23 onwards, my lord. This is of 2016. Lordship, in 2021, the state came up with a regulation notification that short-term leases would be converted into long-term leases, and that for that purpose, proper execution of lease deed would be done. That
lease deed with whom?
With the person who has entered into.
Correct. So you entered into the first lease agreement, entered into with the Pramod Kumar.
There was no lease agreement. Well,
Whatever it is, with the mutual consent, you are using the land of the Pramod Kumar for mining.
Pramod Kumar is my deputy, my lord. He is my person. He is basically doing it in my stead. I have also annexed
whose land you have taken?
That is the government's land, my lord.
So
the land is the government's land.
So government land which you have taken, the government might have been given some authority to use that land. Where is that authority?
Well, that authority, me, so far as the petitioner is concerned, Bongshidhar, but the Pramod Kumar was floated, my lord. The lease was taken by me, my lord. I had made the payments. Pramod Kumar was.
Correct. You have taken the government land on use, on lease. Okay. Then thereafter you appointed Mr. Pramod Kumar. He was running as your deputy.
To be very candid, my lord, from the day one, which is page 23, my lord, everything was taken in his name, my lord. Everything was taken in his name. He had gone astray from me. That is an internal dispute, my lord. Pursuant to which, my lord, I filed a civil suit. I know I have no remedy before this court so far as that is concerned. I have obtained an order of injunction. That is valid. That has been extended time
So
to
there
time.
is no order with regard to against in favor of you by the authorities.
No, my lord, no favor. But
so land has been given to Mr. Pramod Kumar.
The mining lease has been given in favor of Pramod Kumar, but the payment, my lord, your lordship would see. I need to show my bona fides how I am in the picture, my lord. When from page number 30, my lord, which is annexure P2, my lord. These are, your lordship will find, this is a joint account. This is an internal arrangement, my lord.
So, Pramod Kumar was the successful bidder in 2016.
He was my man.
Huh?
He was my man. Pramod
Maybe,
Kumar was my
but on record, Pramod Kumar is in.
Well, I can't stand in that way. I agree.
Correct.
I completely bow down to that.
Correct. Then
there
is no agreement between you and Mr. Pramod Kumar
That's
also.
right, my lord. That is why we obtained an injunction, my lord.
Correct. So what the writ court will do with regard to the private dispute?
That's right, my lord. Only one thing, my lord. The writ court, my prayer before my lord is at page number 49. I say, my lord, if even after filing the suit and obtaining the injunction, if a long-term lease is executed in his favor while that internal dispute is still persisting, where I have made the payments, I have shown bank accounts, my lord, joint bank accounts, the money has gone from me. He's only my face, nothing else. Today he has gone out of my umbrella, he's gone out of my shadow and now he's trying to get it his own name, my lord. That is the difficulty. So I can't say and come to the writ court that please, my lord, no, pass an injunction against him. I've obtained that, shown my bona fides to the civil court, and at page 49, my lord, this notice comes pursuant to a notification which requires today, as on date, my lord, a further long-term lease execution. If that lease is executed in favor of Pramod Kumar, my lord, I'll be severely prejudiced, my lord. That is the difficulty, my lord. My suit is pending. My suit is pending and I have a valid order of injunction which I've communicated to the government in my demand letter. My lord, the infirmity in the writ petition I have mentioned, my lord.
Sorry.
My lord, kindly, my lord.
How the writ?
I am led, only one thing, my lord. I was only instructed to, lordship, I was only instructed to withdraw this with the liberty to file afresh on the self-same cause of action because throughout my writ petition, my lord, I mentioned the wrong date, my lord.
No, wrong date. I will allow you herein now to correct it. But with how your writ petition is maintained, how you can say? See, the Pramod, the private respondent, has participated in the tender process. He was declared as a LOI and he was given, though you have made the payment. That's why that is the called the Benami.
No, my lord.
That is called the Benami.
I'll just indicate one more document, my lord.
You have put one third person in front. You are backing up. Now, the front person is giving you back. Then you are coming before this court.
Very well, my lord. May I just indicate two more documents? My lord, page number 32, my lord. This is a power of attorney executed by that respondent, private respondent, in favor of a person of.
No, nothing can be done in nothing.
And my lord, page number 34, my lord, it's an agreement for mutual settlement. My lord, I know, my lord, so far as these documents are concerned and the rights stemming from these documents, I have a remedy before the civil court and I've taken that, my lord.
Correct.
I've obtained an order.
What the writ court will do?
Only one thing, my lord. If the execution is carried forward, my lord, of the lease deed in favor of Pramod Kumar.
Why you not made the authority in the civil suit as a party?
We have indicated, we have communicated the order to them, my lord.
Not communicated. Communication will not do. You have to make the authority in the civil suit as a party.
Is the time frame, my lord. If so required, we'll add them a party as well.
You add the party. If you
Party,
want the order on merit, then I will dispose of. You want to withdraw this, you withdraw it. Otherwise, it is your choice.
My lord, may I request one thing, my lord? Well, I am led by Mrs. Sutapa Sanyal.
You are argued the matter, no further senior, nothing. You are argued the matter.
Kindly, very well, my lord, kindly allows me to, my lord, withdraw this with, that was my instruction, my lord. Kindly allows me to withdraw this so that I can file a same-self cause of action. Kindly allows this, my lord. Your lordship will dismiss it on merit next time, my lord.
Counsel for the petitioner, press for time to file, press for leave to withdraw the presented application. But I will not grant any leave because there is no merit.
My lord, your lordship will not grant anything today, my lord.
The counsel for the petition press for leave to withdraw the incident application. Leave is granted. WPA number 5143 of 2026.
Self-safe cause of action, kindly, my lord, adds that.
Dismiss as returned. Affidavit of service be kept with the
Yes. Self-safe cause of action kindly allows that.
That's why I'm telling you, I will not get because you know, place is the merit. Next.
I'll try, my lord, I'll come back.
For the respondent bank.
Yes. Yes.
Respondent bank or not?
Which matter?
240. Item 14, your lordship.
Which was the petitioner? None appears on behalf of the petitioner. No accommodation is sought for. Let the matter appear in the combined monthly list of July 2024. 2024. Next. Call a list, call Corona.
My lord, I am appearing for the petition.
I am for the state respondent.
My lord, in this matter, my lord has directed on the last occasion to file affidavit of service, directing the respondent numbers 8 to 12 again to appear in this matter, my lord. I'm ready with the affidavit of service. My lord, in this matter, the bank account of the petitioner has been frozen since since 30th May 2024, my lord. And the petitioner is carrying on a retail business, my lord. He is not directly linked with the FIR, my lord. His bank account has been frozen without any kind of magisterial order under section 107, my lord. And there are several high court order as well as the Supreme Court order where it says that no blanket freezing can be done on a bank account. And if there can be anything that can be done, that is a lien that can be imposed on the account. And since he is not directly linked, his account has been frozen as a layer 2 transaction, my lord. My lord, kindly come to page number 31, my lord.
Who is appearing for the 8 to 11? Nobody is appearing. Yes.
My lord, kindly come to page number 31, my lord. Annexure P4.
31.
Yes, my lord.
Hmm.
My lord, here my lord would see is that the transaction date is 30th April 2024, and the account has been frozen on 30th May.
April.
Yes, my lord.
How much? What is the transaction amount?
Transaction amount is the disputed amount is 81,000, and the transaction amount is 1 lakh.
1,09,236.
9,000. Yes, my lord.
And disputed is 81,000.
Yes, my lord.
That is on 30th April.
Yes, my lord.
And your account was freezed on when?
30th May
Complaint
2024.
dated 30th May.
My lord would
What
see
is your
that
name?
this is my lord, the complainant name is written in the
Subhasisdar.
Dara Temuras Pestonji.
Huh?
It is written Dara Temuras Pestonji.
Where it is?
Here, my lord, annexure P4, 31 page.
Dhara Temuras Pestonji. Is the company name?
No, my lord, maybe some individual. I do not know since I am running a business.
This account is yours.
This account is mine. But since this is a layer 2 transaction,
Complainant details.
I had taken monies from some individual.
No, in whose name the account is there? In your name? Petitioner.
Yes, my
Where
lord.
is your bank account?
Yes, bank, my lord, Dalhousie branch.
Where is that?
My lord, it is
What is page 30, page 31? There is a complaint.
Yes, my lord.
The complaint received by the bank.
Yes, my lord.
Against you.
Yes, my lord. And
Against your
transaction
particular
details
account.
has been there in annexure P5, my lord.
P5?
Page 39.
It is your.
Sorry, 34, my lord.
Page 34. 30th April. Where is the 30th April? There is no 30th April here.
No, annexure P4, my lord, records 30th April.
Annexure P4 with regard to the complaint
Yes,
the
my
bank
lord.
has
And
received.
in this, yes, there is 30th.
Where is your bank account with the amount, transaction of the amount?
Yes, my lord.
30th April.
My lord would see in page number 35, my lord.
There are so many. This
Yes,
is
my
only
lord, there is
no page 31. There are so many, but you are only concerned with the first one.
No, my lord.
All.
Page 31, I am concerned with the first one.
No, nothing on the other is not of
No,
you.
No.
Other is not belongs to you.
No, others doesn't belong to me. And page 35, my lord, from the last, my lord would see that is 6th position from the last, page 35.
1,09,000. 1,09,236.
236, my lord.
That is a deposit.
Yes.
That has come to you.
Yes, my lord.
So out of this 81,000 is they are
Disputed amount.
disputing.
Yes, my lord.
So how it has been, who has deposited in your account?
My lord, I am running a retail business, my lord. I take money from my different customers. My lord, so one of the customer is this Vikram Broshak, and he has come, and on one occasion only he has transferred the amount to my account. And thereafter, my lord, I received that like my PAN card as well as my bank account has been frozen, my lord.
Yes.
I am for the state, my lord. She's appearing
Which
for
was
yes.
the bank?
I'm being led by Mr. Sai Pratita.
Yes. What is your submission?
On last occasion, we had already, Your Lordship had already directed funds to 8 to 11.
Yes, they have served, but nobody is appearing. What is
My lord, the bank has already said that they are not having any kind of grievance, and on the basis of the complaint received by the Pune cybercrime department, they have frozen the account.
All upon the direction from the cybercrime department. Ordered the court, honorable court has given upon us to not.
The petitioner has filed the present writ application. Your judgment?
Yes, my lord.
Which judgment?
Extra copy also.
My judgment is there. You're not having that.
No, my lord, I don't have.
इससे पहले वाला फाइनल तुम लोग तो बम दिया है। इससे पहले वाला एक फाइनल था ना, छोड़ दो सब गमान रहने दो, सब गड़बड़ कर देगा। The petitioner has filed the present writ application, praying for a direction upon the respondents number 4 and 5 for defreezing the saving account of the petitioner, being account number 01905240 5 times 0 919, maintained by the petitioner with the Yes Bank Limited, Dalhousie branch, Stephen House, full stop. The counsel for the petition submitted the petition is maintaining his saving account with the respondent number 4, but all of a sudden on 30th of April 2024, 30th April, when your account was
30th April 2024, my lord.
Page 34 is saying it was up till the 1st of May.
Yes,
When it
my
was,
lord,
it was freezed.
It was freezed on 30th May 2024.
30th May?
Yes, my lord.
क्या बोला? 30th May 2024 has freezed the account of the petitioner on the ground of receipt of complaint from one Dhara Temurus Pestonji, Pestonji. She submit that the bank has freezed the account of the petitioner on the allegation that on 30th April 2024, an amount of rupees 109,236 1,09,236 was deposited in the account of the petitioner, out of which 81,000 has been disputed by the complaint dated 30th May 2024, and as such, as per the instruction of which, how you freezed? Only because of this complaint, not by the authority. Who has sent this complaint to you? Who has sent this complaint to you?
साइबर क्राइम अथॉरिटी पुणे
क्या बोला? Of the cyber crime authority of Pune.
पेज 31
Cyber crime authority of Pune. Full stop. The petitioner submitted subsequent, when the petitioner came to know about the freezer of the account of the petitioner by the bank, the petitioner has made several requests to the bank, but the bank has not defreezed the account of the petitioner, due to which the petitioner is not in a position to operate the said account. The petitioner further submitted the bank has also blocked the PAN card of the petitioner. Per contal, an advocate appearing for the bank submit that the bank has received a written complaint from the cyber crime Pune, wherein it is mentioned that one Dhara Temurus Pastonji has made a complaint to the cybercrime authority, and during the investigation by the cybercrime authority, it was found that out of the transaction of rupees 1,09,236, an amount of rupees 81,000 is a disputed one, and accordingly, as per the advice of the cybercrime branch, the bank has freezed the account of the petitioner. The petitioner has made the cybercrime authorities as respondents from 8 to 11, but in spite of service of notices on 2 occasions, the respondent number 8 to 11 failed to appear before this court. Full stop. The petitioner has relied upon the judgment in the case of Nilkanth Pharma Logistic Private Limited, versus Union of India and another reported in 2025 SCC Online Delhi 1055 and submit that in the said case also the
My lord, para 13, my lord, from para 13, 14, 15, 16, my lord. My lord, para 11 also.
not this. You not bring my judgment. I have categorically and by referring the division bench of the Kerala High Court. क्या बोला? Judgment छोड़ दो, हटा दो. In the case of so and so, ठीक है? In the case of so and so, this court, this court find that though the bank has freeze the account of the petitioner on the complaint received from the Cybercrime Authority Pune, but neither the investigating agency, neither the Cybercrime Authority nor the bank has come forward, has brought any record in the present case that the Cybercrime Agency have obtained any order from any court for freezer of the account of the petitioner under section 106 and 107 of the BNSS. Full stop. In the case of so and so, this court held that considering the submission made by the counsel for the petitioner, counsel for the respective parties peruse the materials on record, this court find that the bank has freezed the account of the petitioner on receipt of the complaint of the Cybercrime Pune that the transaction made on 30th April 2024 with regard to an amount of 1,09,236, there is a disputed amount of 81,000, and the same was informed to the bank on 30th of May 2024, and the bank has freezed the account of the petitioner. Considering the above, this court find that there might be an investigation carried out by the Cybercrime Authority, but the Cybercrime Authority failed to appear before this court in spite of service of notice. Even they have not communicated either to the bank or to this court that the Cybercrime Authority have received any order from any court with regard to the freezer of the account of the petitioner under the BNSS. Considering the above, this court find that the disputed amount is only rupees 81,000 out of rupees 1,09,236. Accordingly, the bank, the respondent number 4.
Respondent 4, my lord.
5 and 6.
Respondent number 5 and 6. No, 5. 6 is the Union of India.
Respondent number
4 and
4 and 5.
I'm so sorry, madam.
Respondent number 4 and 5 are directed to defreeze the account of the petitioner by allowing the account of the petitioner as well as the PAN card of the petitioner, and to unblock the PAN card of the petitioner and to allow the petitioner to operate the bank account by keeping the disputed amount of rupees 81,000 in lien.
Yet full, my lord.
WPA disposed of.
My lord, is there any direction related to the time frame, my lord?
Immediately.
Grateful, my lord.
But in that case, on the last occasion, it was recorded as 4 and 5. But what I find is 4 and 6.
4 and 5. 4 and
Mr. Suri Saraj is appearing on behalf of the petition.
yes.
May I take your leave?
For only not today.
Yes. Not today. Next. जो आज पासवर हो रहा है ना सब पीछे आएगा हल्का जितना ऊपर है yes next
Lordship. I will for the
17
respondent
also?
number 4, Lordship.
not today next
Affidavit for refund. Indiscriminate freezing of the account balance for very small amount, unverified small amount.
yes
Indiscriminate freezing of my account balance.
but where is the bank with nobody's there nobody's there how it can be disposed of
I will text for
not today next
Matter, my lord, I am for the petition. I am bringing a short passover here.
But I'm for the respondent.
I am for the petition.
What is the matter?
In this case, Your Honor, my lord, a lien has been marked.
huh
A lien has been marked in my account, my lord.
lien or freezed
Defreezed.
lien or freezed
Lien defreezed.
account is freezed or lien
Freezed, Your Honor.
freezed when it was freezed
It was freezed on 17th November 2025.
17 November
And
2025
again, it was first lien on 28th July 2025. Thereafter, by the order of the 17th Judicial Magistrate, Mumbai, it was debit freezed on October 1, 2025.
officer in charge cyber
Thereafter,
crime
on
Goa.
November 3rd,
Where is
2025.
the affidavit of service
Affidavit services.
have you served Goa served
Yes, sir. Yes, my lord.
There are two authorities. There are two authorities. One is Cybercrime CID,
Goa
respondent number 3, Goa,
Hmm.
and my lord OC Cybercrime Police Station, Birhan,
Mumbai.
respondent number 4.
Lord, I apply for the petition.
Hmm.
In the case of an innocent third party.
where is the service
Service.
served
Yes, sir.
This one.
no service can you see so the service of the cybercrime Goa and cybercrime Bombay there is only tracking there is no delivery report
This is page 10. So item delivered on 16th January.
home so that is one there are four speed posts show me the 4 delivered receipt
One is Mumbai.
And my no authority has been made party, my lord. Only ICICI Bank and then my lord, the Cybercrime Authority.
you are appearing for whom
1 and 2.
1 and 2 so what do you want
Those are private banks. That is my submission before. Those are private banks.
Notice your lordship kindly see 16 and 17. Lord. That is the first service at 17.
so it is served you show me
और एक copy.
That is ICICI Bank, delivered to ICICI Bank. Item delivered, that is 9. Item delivered to Alam Bazar IDC, not to the party. Now kindly come to this item delivered to Ribandar, SO, service sub office, sub post office, not to. Though the petitioner has filed the affidavit of service, but this court finds that the service has not been affected upon the respondent number 3 and 4. London Council appearing for the respondent number 1 and 2. You are
1 and 2.
1 and 2 is present. In view of the above, petition is directed to serve the notice upon the respondent number 3 and 4, informing the next date of hearing, and to file the affidavit of service on the next date. Let the matter appear on 8 May.
Instead of 8, can it be any other payment? 8, I have some.
7. 7.
May I take you?
Yes, next.
My lord, I am for the respondent number 5, my lord. I have been led by Mr. Uttiorai for personal difficulties. I am for the respondent number 5, my lord, and in this matter I have been led by Mr. Uttiorai. So, but due to personal difficulties, he could not attend today, my lord. So
What is the matter?
Praying for him not today, my lord.
Let me see. What is the matter?
What is this matter, my lord?
If required, I will adjourn. If not required, then I will.
I am for the statement. My lord, the petitioner, my lord, the mother of the private respondent, my lord. There is an order, my lord, by the SPO, my lord, to pay maintenance. Now, my lord, your lordship has already, my lord, previously dealt with, my lord, this subject, my lord, in a previous, my lord, another petition, my lord, where your lordship, my lord, held that, my lord, the execution of the order, my lord, cannot be, my lord, done by the, my lord, the writ court, my lord. Only difference is, my lord, in this instant case, my lord, there are, my lord, execution, my lord, petitions filed before the SDO, my lord, on a number of occasions. As of today, my lord, 1,40,000 is pending, my lord. Nothing has been, my lord, no steps have been, my lord, taken by the SDO and subsequently, my lord, by the police authorities. That is
Subsequently?
By the police authorities, my lord. There is, my lord, only, my lord, kindly see. My lord, page 43 kindly comes.
43. That is a police authority. Who is a subdivisional officer?
Yes.
Because of today immediate action.
My lord, the only step has been taken.
Huh?
This is, my lord, the only step taken. The SDO has, my lord, on 25 January.
Where is the order of the SDO? Directed the authority to, directed the police to arrest.
Page 43 is the only.
That is only. There is no order. In the execution proceeding, there no order is passed by the
in execution proceeding, my lord, no order has been passed. My lord, after my direct us not to decide the execution proceeding expeditious.
No, I am telling when you bring the amount here, senior citizen.
Yes, my lord.
When you bring the amount before this court.
My lord, kindly.
Because now you will say this has happened, now this has happened, the officers change. That will happen. Now you tell me when your client will come with the check amount.
Mainly, actually, I have been led by Mr.
Maybe I am asking because see.
Kindly one day accommodation, my lord.
Come tomorrow with the check.
My lord.
Come tomorrow with the check.
My lord, kindly grant liberty to.
I will not, because senior citizen, I will not adjourn the matter. This is already authority has passed an order for payment. You are not paying the amount. You have managed the police authority. Police authority are not executing that. Come with the 50% amount, then I will allow you.
My lord, so kindly.
Then you ask the time, then I will pass an order on the full amount come.
My lord, kindly 1 week, my lord, 1 week.
That's why 1 week I am giving, but with the demand draft, not check. Then again there will be 138.
Okay, my lord, kindly, my lord, 1 week accommodation.
You will bring the amount.
My lord, I will ask to my senior, my lord, so kindly.
I know why the senior is not here.
My lord, due to personal difficulties.
I know that is the personal difficulty. No, the court will catch hold of your senior.
Okay, my lord, kindly.
Senior citizen maintenance amount, sir.
Yes, sir.
This is not with regard to the husband and wife dispute. They are senior citizens.
So, my lord, kindly 1 week accommodation, my lord.
I am keeping on Tuesday. Come on that day. If you will not come, then I will pass directly the SHO, the officer in charge, to bring you on arrest before this court.
Kindly. So my kindly, sir.
When?
Thursday, my lord, 2 or 3.
Thursday is not. As per the prayer made by the counsel for the respondent, let the matter appear on 5th of May within 10 matters.
Wait. 5th of May.
Yeah, please, your lordship. That matter where all my current 7 accounts have been frozen by the bank only upon the basis of an instructions given by MHA. But that notice on the basis of which the freezing has been done has not been communicated to us. It's only a bank's email which has come to us, and all my 9 current accounts have been frozen. Petitioner is one of the biggest dealer in iPhone and iPads all around West Bengal and has shops in all the prominent malls of Calcutta. But in the last occasion, the union appeared, the bank did not appear, and your lordship has pleased to pass an order on 21st of April 2026 that we were asked to serve again a copy that the matter will appear today. Your lordship has made it clear that if the bank does not appear, expiry orders will be passed again. So we have served upon them, your lordship. This is affidavit of service, and they have received. Lordship, we see the annexure part, the track records that we have annexed, it shows that they have received on 24th of April 2026. Lordship, I am covered by your lordship's judgment which was delivered in my matter, that promoted hotel matter, that without obtaining orders of the jurisdiction magistrate under 107 of BNSS, the accounts cannot be frozen. Here, all my current accounts, my business accounts have been frozen. I'm not able to do any business.
All accounts. All the
accounts. Yes. Your lordship will see the impugned communication of which I have annexed to my writ petition at page 25.
What about the other respondents have not served?
Lordship, all the respondents have been served, your lordship. The affidavit of service I have filed on the last occasion. Your lordship, the principal answering respondent is the bank. Union of India and the are not the answering respondent. Bank has to come and justify as to why they have frozen the account. Now, the difficulty which I am facing is that in my current accounts, the sum of more than 41 crores is lying. There is a new model of iPhone and iPad.
What is the dispute? What is the reason?
Page 25. There is no reason assigned. Kindly come to page 25.
Issued by the bank.
Issued by the bank on 23rd of March 2026. Kindly see from the 4th paragraph. We understand that our branch official Meghdood has emailed you on March 17, 2026 and has informed you that all the account in the name of Umang Business Consultant is debit frozen status due to negative match found in MHA cyber case. And as per the communication received by the MHA, at bank level, we have reviewed the matter and the same has been highlighted to the respected authority. For any further assistance, please contact the relationship manager. Now, lordship, after receiving this notice, we have given a demand justice as to why you have frozen the accounts. Kindly let me know the reasons for that. Page 27. Because they referred to a communication of MHA, but MHA has not forwarded any communication to us. It is only the bank's email. Kindly see 27. We are writing on 28th of March to the Joint Secretary Branch Manager. Demand notice for immediately decreasing all the bank accounts maintained with HDFC Raniganj branch.
Is there any proceeding initiated? Willful default?
They have not replied to this email. They have been sitting tight. After receiving this email, no information has been disclosed. In fact, 4th April 2026, for one day, they have defreezed the account. Again, they have frozen. No reasons assigned. We have repeatedly issued them notices that kindly let us know the reason for defreezing. Nothing has been communicated. They are keeping the hold on my account. The lordship will see the details of the accounts I have given. Lordship sees at page 21. These are the 7 current. Sorry, it was not 9. It was 7 current.
Yes.
7 current accounts. Your lordship will see.
41 crore.
Yes. Your lordship, I run a business. I am a dealer. I am a dealer of iPhone and iPads, and I have one of the biggest in West Bengal, a very well-known entity. And I have shops in all the prominent malls of Calcutta.
Which bank?
HDFC. Blanket email communication. All my current accounts.
Who is appearing for the HDFC on?
We don't know, but we have served as per your lordship last order. We have served. They have received, but they have chosen.
Today, maybe due to the resolution of your bar.
Is the difficulty which I will be facing today for pressing for further orders.
Lordship, may I assist, my lord? I generally appear for HDFC Bank, my lord. Yes. If it is being communicated which branch, my lord,
why the bank is not appearing? There is a clear.
I appear for the, my lord. Which branch? My lord, I shall
Raniganj branch,
communicate to the SDF. My lord, I shall definitely communicate to the SDFC legal team. My lord, they will definitely appoint. My lord, kindly
It is
keep
the
it.
Raniganj branch. I am recording your name. You take instruction. Come on 6th.
My lord, my lord.
May I only pray for one thing? Today I cannot because of the resolution. If your lordship only fixes a time on 6, I will not take more than 5 minutes. Grateful.
The petitioner has filed the affidavit of service in terms of the order passed by this court dated 21st of April 2026. But let the same be kept with the record. So-and-so appearing for the bank and prays for time to take instruction. Accordingly, for the interest of justice, the case is adjourned. Let the matter appear on 6th of May 2026 within 5 matters.
I am grateful.
Under the same heading.
I am extremely grateful for the indulgence.
Take instruction, madam. Come on that day.
My lord, my lord.
Yes.
Lord, I pray to appear on behalf of the petitioner. Before I start, Lord, may I hand over the affidavit of service? I have seen personally, Lord, sir.
What is the matter?
Ascertain sum from the respondent authorities out of 3 awards. They admitted that 15% interest on the remainder is due and payable to me on the basis of 2 FDRs. There were 3 awards, but I must indicate. In the awards, rupee X, Y, and Z were given to me. I was not happy with X, Y, and Z. I wanted more. I filed appropriate applications till 2023. The learned court having jurisdiction said that no, X, Y, and Z is only what you are entitled. So till X, Y, and Z is entitled to me, the respondent authority said, let everything finish, I will pay you. The second the proceedings finished, they admitted their payability, they admitted that interest is due and owed to me, then they stopped paying. 86-year-old gentleman from 1988 running from pillar to post.
So you left the civil suits. Now you are entering into the read with the money matters.
Not ascertain sum. Civil suit, the only difficulty with a civil suit will be, my lord, I would be barred by limitation.
Writ.
Only remedy available. Ascertain sum, they've admitted that they are to give me that money. Had it not been an
So what is your prayer?
It kindly comes to page 16, my lord.
Yes.
10,000 rupees.
Immediately refund the 2 FDR. Amounting to rupees 10,000.
And interest around 15%.
How you can get the interest? Because what is the amount in the fixed deposit? What is the interest in the fixed deposit?
They have admitted 15%.
Maybe. Where is the fixed deposit?
My lord kindly takes. May I just show 2 pages to my lord?
Where is the fixed? First you show me the fixed deposit receipt.
It's not with us anymore, my lord.
What you are telling, sir?
It's not with us anymore, my lord.
How? You made the fixed deposit. You will not get the fixed deposit receipt from the bank.
This is not from the bank, my lord. I'm sorry. May I just reiterate the facts?
From whom?
Railways.
Railways.
3 contracts on the basis of which I had to give some money to them, not a fixed deposit with the bank.
Where is the railway authority?
Not. May I just show one thing which is a hurdle that
let the authority come. Though the petitioner appeared and filed affidavit of service, but none appears on behalf of the respondent. According cases adjourned, let the matter appear on 13th May. Next.
And I know this is a sentence that I will be making possibly, my lord.
Under the same heading, within 15 minutes.
So very obliged. So
next.
Yes, my lord, I am for the petitioner here.
What is the matter?
Banking.
Banking, which bank? Have you served?
I have served, my lord.
But what can be done? Not today. Come on 4th.
My lord. Still result, my lord.
Result? You are not affiliated to any political party? No. Or you are a candidate? Are you contested the election? No. I am also not contested. So on 4th we'll do.
On behalf of the petitioner, my lord, I'm praying for some time because service is not complete.
As per the prayer made by the counsel for the petition, let the matter appear in the combined monthly list of June 2026. Next. File 9. 26.
I'm appearing for the petitioner, Lordship.
Yes. What is the matter?
This is my excuse of service, Lordship.
Freezing account.
Lordship, for the gun license.
Gun license.
Lordship, I'm a Brickfield license.
Huh?
I'm a license holder of a Brickfield, Your Lordship, and I own several other substantial.
Your license holder of?
A Brickfield, Your Lordship.
Brickfield.
Yes.
Hmm.
My trade license is at page 13, Your Lordship.
Hmm.
I own several other landed properties, and some local magistrates have been creating problems in those landed properties. So that, they have stolen bamboos from there. They two writ petitions were filed before this Honorable High Court. Police picketing was also directed. Several FIRs have been filed. So there is a threat on my life, Your Lordship. I was badly beaten up. I was hospitalized.
Earlier there was a license, no?
No, there was no license. I had applied.
It's the first time.
This is the first time.
When you applied for?
I have applied on page 24, Your Lordship, before the DM. 30th July 2024, Your Lordship. 2024.
Page 24.
Yes, page 24.
Hmm.
And I have applied on 30th.
What you applied for?
For the gun license.
Gun license of what? Which type of the gun?
Pistol, Your Lordship.
Pistol. That's why gun, you're telling that the pistol. Hmm.
It's all the relevant documents, Your Lordship. And thereafter, inquiry was held, and I have inquired. The report has also been filed.
Where is the inquiry report?
Lordship, internally I have heard that inquiry was held, and internally I heard that report has not been filed. My only prayer is let the DM consider my application and dispose of within a specific period of time, Your Lordship, because there is immediate threat to my life and my family.
So what you will do with the pistol? You will threaten the other person?
For my safety, Lordship, absolutely.
You will threaten the persons you are having the pistol.
I say that with some responsibility.
The grievance of the petitioner in the present date application that the petitioner has applied for grant of arm license within bracket pistol before the concerned authority, that is the district magistrate Krishnanagar Nadia.
Yes,
Krishnanagar Nadia on 31st of July 2024. Along with all the relevant documents. He submitted on receipt of the said on receipt of the application filed by the petitioner, the police authorities also verified the characters of the and incidents of the petitioner. But in spite of the same, till date, no license has been granted, and the application filed by the petitioner is still pending before the district magistrate Krishnanagar Nadia. Police of counsel for the petition submitted, the petition will be satisfied if this writ petition can be disposed of by directing the district magistrate Krishnanagar Nadia for consideration of the application filed by the petitioner on 31st of July 2024 for grant of arm license within bracket pistol. Consider the submission made by the counsel for the petitioner. This court find that the petitioner already made an application before the district magistrate Krishnanagar for grant of arm license within bracket pistol, but that has not been considered till date. In view of the above, the writ petition disposed of, directing the district magistrate Krishnanagar Nadia, that is respondent number 2, to consider the application filed by the petitioner for grant of arm license and to pass a reasoned and speaking order after giving an opportunity of hearing to the petitioner within a period of 6 weeks after receipt of this order.
Let the decision also become.
Pass reason. Pass the reason order within क्या बोला? Within 6 weeks and to communicate the same to the petitioner within a week thereafter. Next. None appears, no accommodation. July 26 monthly. Next.
The Lordship, I am for the petition. The Lordship, this matter is regarding Chittaranjan Locomotive Works. Earlier, the Honorable Court had directed them to serve opposite or affidavit in opposition. But Your Lordship, I have not received the same motion.
Respondent direct to file affidavit in opposition to the writ petition within a period of 4 weeks. You are not received.
No.
Tender credential. What is the matter? Tender?
Yes, Your Lordship, regarding tender, Your Lordship. I have challenged the rules, Your Lordship, which the additional rules of the Chittaranjan Locomotive Works, Your Lordship.
Okay. So what do you want?
Kindly pass necessary order, Your Lordship.
Since appearing for the petitioner, none appears on behalf of the respondents. By an order dated 2nd February 2026, this court directed the respondents to file affidavit in opposition within 4 weeks. Reply, if any, thereto filed within 2 weeks thereafter. In spite of police counsel for the petition submit that the petition has not received any affidavit in opposition. There is no affidavit in opposition record. For the interest of justice, the case is time to file affidavit in opposition is extended for a further period of 2 weeks from date. Reply, if any, thereto 1 week thereafter. Full stop. Let the matter appear.
And for the respondents.
Where is your affidavit?
We have
Affirmed.
affirmed, Lordship.
Why you are not served?
Lordship, we could not contact, Lordship. We are serving right now, Lordship.
There is no back page in the writ petition. There is no contact number. Why you cannot
There was
contact?
contact number. We made the service letter also, Lordship. But we couldn't connect.
Okay, give the copy. Record and note. You will file reply. Get it in. Respondents have filed affidavit in opposition after serving the copy to the counsel for the petitioner. The petitioner prays for time to file affidavit in reply. Let affidavit in reply be filed within 2 weeks. Please the matter on 14th May.
Obliged, Lordship.
Next. But where is the other side? But today there is a resolution. The court cannot pass out. June. If you want the fixed date, then it will go first week of July. What can be done? If you insist, I will. But immediately within 1 minute, the order will be quashed and again it will be remanded to this court. I have no problem to hear and pass an order. One day it is not possible. Next week, because 4th you persons will not appear. 5th, 6th, 7th, 8th, only 4 dates are. What your challenge? Sanctioning order. Sanctioning order for prosecution. For prosecution under the POC Act. SFIO. 20. Yes. Companies Act. So appearing for the petitioners, none appear on behalf of the respondents. For the interest of justice and due to the bar resolution, the case is adjourned. Let the matter appear on. Come on, June. Let the matter appear on 14th May under the same heading. Same heading under the same position.
30. State, my lord.
Yes.
My lord, I am for the Howrah Jila Parishad led by Mr. Shibujyoti Chakraborty, my lord.
Yes, sir. What is the matter?
Before I get into the page number 123.
Yes. 123.
My lord, my instructions is that
Already very categorical. And there is no ambiguity in this. No lawsuits categorically directed. It is found that the petitioners are L1, but under what circumstances the authorities on receipt of the email from an unsuccessful bidder is taking a clarification from the WBL DPCL. This court finds that the act of the respondent authority is totally against the law. Para 7 says, my lord, of the same order, the writ petition is disposed of by directing the respondent number 3 to 7 to take appropriate decision by January 28, 2026 with regard to the tender submitted by the petitioners, wherein the petitioners have been declared as L1.
Yes.
My lord, logically, the action after declaration of appropriate action.
Now what has happened now? Now what has happened? Cancelled.
It is pending and
No, they have cancelled your tender. They cancelled the tender process.
they have cancelled the tender process precisely on a frivolous email from an unsuccessful bidder for no reason. But if this thing is allowed to continue, then no tendering process can take place. Any unsuccessful bidder will make an email and stall the process. And it involves public money also, because tendering cost the government.
Yes.
So, I don't, if I am allowed to say so, if this kind of action is allowed to take place by any unsuccessful bidder, then none of the government projects can take place.
Yes.
And go further. And
Yes.
whereas your lordship has categorically directed to take appropriate action of declaration of L1. Now the appropriate action supposed to be the offer. There is no other alternative. And that too on a very, very frivolous email from an unsuccessful bidder. If I fail to understand, my lord, how can authorities take such a decision of cancelling the whole process?
Yes.
my lord, Mr. Chakraborty is not well, my lord. So, my lord, I'm praying for a
no. You submitted is appearing through online. Now you're telling that you're is not is unwell.
My lord, he is unwell, so.
Appearing for whom?
Howrah Jila Parishad, my lord.
Huh?
Howrah Jila Parishad.
Howrah Jila Parishad. Who is appearing?
Mr. Shibujyoti Chakraborty is appearing, my lord.
Okay.
He is not well, my lord, so I'm praying for not today, my
So
lord.
how you can cancel this tender after making some submission before this court? You at that point of time, your only contention is that yes, he was L1, but there was some confusion with regard to the objection raised by the private other tenderer. So that's why you are asking the tender. So this court has granted to how you what is the reason for cancellation?
My lord, actually the brief is not with me and he is leading me in this
Not
matter,
today.
my lord. Grateful.
What can be done? Your bar has a resolution. None appears on behalf of either of the parties. No accommodation is sought for. Let the matter appear in the combined monthly list of July 26. Next. Same. Same. Who is for the other side? What is your grievance?
Technology through IBM. As per 21G, there is a age bar. The petitioner number 1, is the
When your marriage was consummated, solemnized, huh?
4 years back.
Where is that?
Marriage consummated 1st January 2002, and the petitioner have one children, who is died.
When he died?
Died on 16th March 2025. I annexed the certificate. That is page 20.
Then?
After that, the petitioner number 1 is the out of age bar.
What is the age of the petition number 1? What is the age of the petition number 1?
1 around 41 years. That is within age limit.
Petition number 1 is the wife.
Petitioner number 1 is the wife.
Then?
Petitioner number 56 years.
56.
Yes. That is out of age as per 21.
Okay.
Also decided the issue and
But where is your medical document? Clinical, where is the clinical chart?
that is they do not allow for that time.
That is with regard to the final. First, you have to undergo the clinical test, because earlier there was a child. Unfortunately, child passed away. Correct. Now you have taken a decision to have a second child. So first you have to go to the hospital. First you have to prove that at present you are not able to conceive. Correct. Second, then you have to prove that yes, at this stage the IVF procedure can be done because fit for go for the ART procedure. So this document, only because of the age group it cannot be conducted. Then this clinical, you go to the clinic and not age. That's what I'm telling. With regard to age bar, that is different thing. That is on the face of record itself. But with regard to the other clinical, whether you are able, your husband is age bar, whether you are able to conceive. So all the things are report. You go to the hospital. I am giving a liberty to file a supplementary affidavit. Bring the document. Go for the total clinical test. Bring the record. Then the court can pass an order. The learned counsel for the petitioner pressed for time to file supplementary affidavit by disclosing the clinical chart of the parties to prove that the parties had been to the hospital for their medical treatment, and only due to the overage, the petitioners could not go for the ART procedure. Consider the submission made by the counsel for the petitioner. Time the petitioner given liberty to file supplementary affidavit by 2 weeks. Within 2 weeks, list the matter on 20th May. Under the same day. Next.
But I am for the official liquidity, 35.
Lord, I am for 35. I am for the state. Our arguing counsel is unwell today, so saying that the matter will be taken after 7 days.
Which one?
Item 35. I am for opposite party 3.
What is the matter?
directly from that, we are in possession now. Your land is very possession that is without title deed of that particular portion of the land is concerned. That title is not in my concern. Because they are not either who will be created. It is the I am my understand right to this. That I can do that. And getting another bit of leasing that was also into the registry office. So I also added the registry office as a public respondent here. I think
Yes.
My lord, I have, my lord, if your lordship kindly transfer.
Who is the person, concerned authority? You are appearing for?
Official liquidator. My lord, if your lordship kindly turns to page 96 of their application, my lord, that is the order of the Honorable Court of Appeal. Oh.
You are appearing for whom?
I am for opposite party 3. As I mentioned, the arguing counsel is unwell and we would have to file.
You are appearing for 3.
Yes.
And 4 is the main.
But
either bank has those deeds or whether the ARC either these two, any of these two as a deeds or title.
So,
3 is appearing.
my learned friend is appearing for state.
For the state, state has nothing to do. So whether you are having the document.
The instruction that I have is that the document is not with us, but I am praying that it be 7 days time be given so that our arguing counsel can appear, some change can further be made, and we can file an application.
So file the report.
Already in compliance with the order of the Honorable Court of Appeal, official liquidator already handed over possession.
Okay, let us see.
Yes.
The counsel for the petition submitted service is not affected upon the respondent number 4. Accordingly, petition directed to serve the copy of the writ application along with the documents to the respondent 4 within a week from date and to file the affidavit service on the next date fixed. As regard the service of respondent number 1, 2, and 3 is completed. Respondent number 1 and 3 are present. None appears on behalf of the respondent number 2. Respondent number 3 prays for time to file affidavit. Police. This court find that file affidavit. In view of the above, let the respondent number 3 file a report by an affidavit to specifying whether the respondent number 3 is having the deed in question with the respondent number 3 or not. The respondent number 2 is also directed to file the report by way of an affidavit to explain with regard to the deed which the petition is claiming in the present deed application. Let both respondent number 2 and 3 are directed to file the affidavit and file report by way of an affidavit within a period of 1 week from date. After serving the copy to the land counsel for the petitioner, the petitioner is liberty to take exception to the report, if any, within a week thereafter. List the matter on 21st of May 2026. Full stop. The petitioner is liberty and the petitioner directed to communicate this order to the respondent number 2 for compliance. Affidavit already.
I'm deeply obliged.
Next.
My lord, I'm appealing for the respondent.
Yes. Who is for the petitioner? Representation. Restoration application. What is the matter?
Petitioner has challenged the order of dismissal passed by the State Consumer Dispute Redressal Commission in a revision petition. There was a dismiss for default challenging that order. Petitioner has come before your lordship and filed this petition.
Challenging the dismiss for default of the Consumers Forum?
Yes, my lord.
Where is
dismiss
that order?
Of the revisional application.
Where is that order?
Page 80.
Neither the reason nor the advocate were present. Upon perusal of the record, it appears that revision is filed focus, but the focus is not moved by the revisionist. Moreover, it appears to us the CP cost which was imposed by order has not paid by the revisionist in favor of the complaint. In such situations, the State Commission has passed an order.
My lord.
The attorney but to dismiss. But there is no petition.
I find, my lord, there are two more matters on the same ground of dismissal. Another one is 16155 WPA on
That is not listed.
16034.
That is not listed today. Okay.
4 it is.
Though the learned counsel appearing for the respondent is present, but none appears on behalf of the petitioner, let the matter appear in the combined monthly list of July 2026.
But well, Bar has taken the resolution.
My court, if you will ask the time, I will grant the time. If nobody is appearing on the basis of the resolution, I am fixed. I am not dismissing. Come on the next day.
No, since Bar has taken the resolution that no order would be passed.
But what can be done if today I will not? Tomorrow, what the court will do?
But petitioner will be aggrieved. Immediately will be rushing to the
What can be done?
will be coming to the bar.
If today's list, not today. Tomorrow already I have fixed the 20 matters as urgent motion where I can fit the matter. Yes, next.
Great.
Give you password.
Ten. Let the respondent hearing offline.
My lord, item number 10, my lord, I appear for the bank respondent bank, my lord, HDFC.
By the bank, where they put my complete account, but I was covered by all of the order, my lord.
Yes.
Page number 17 is the lordship procedures for a communication or no, this is the lordship order where banking of bank account was not permitted by your lordship.
Yes.
Page number 17 where over an email on the 2nd of April 2026 that they debit freeze my digital transactions. This is my current account of my
Who is appearing for the bank?
My lord, I am appearing, my lord. My apologies, my lord. I am appearing virtually, my lord, due to some personal difficulty. My lord, what is my instruction is, my lord, since there is a communication from the Ministry of Home Affairs, Home Affairs, my lord, two back-to-back complaint against this particular bank account has been lodged, my lord. My lord, and it has been that is why, my lord, it's my humble request, my lord, let the respondent number 2 also appear, my lord, since it's Union of India's presence is required in this matter, my lord. My lord, otherwise bank has cannot come in the way, my lord.
For the Union of India. Mr. Pradipal for the Union of India. I'm his junior.
So what is your instruction?
My lord, answering respondent is number 2 and 3.
No, they are telling that you have instructed. That's why they have defreezed.
That I have no instruction, my lord, at that time.
My lord, may I come back with a short report in form of affidavit, my lord?
Here is code number 6. Code number 6. Yes.
That's why.
He's engaged in code number 6, my lord.
No. No, that's correct. But see, they are pressing the union of both has to be at, then I have to record the both submission, then I have to dispose of. Correct. I appreciate your anxiety on all these things, but they are putting the button to the 1 and they are putting button to the 2. So then what is their exact submission that court has to record in order? Correct. Then the court has to pass an order. She is telling that I have no instruction. Senior is not here. Tomorrow I will pass any order, then she will be in difficulty. Let either I am pass it to her, bring the senior, then I will hear.
My lord, My lord, your lordship has just few minutes back, your lordship has fixed another matter on 6th, my lord. Let it also be fixed on 6th, my lord, wherein I was appearing for HDFC Bank, my lord. In the meantime, I shall file a short report, my lord.
As per the submission made by the counsel for the bank, let the matter appear on 6th under the same heading, in same position. In the meantime, the respondent number 1 as well as the respondent number 1.
Yes,
Respondent number 1 and respondent number 3 are directed to file the report on the
My
same
lord.
heading. List the matter on 6th. Next. List the matter on in the combined monthly list of July. Yes, any matter both parties are appearing? Yes.
Hello, item 38, I am for the petitioner.
Okay. Let call the list. Call the list.
My lord, item 38, I am for the petitioner.
Yes.
My lord, there was a direction upon the state respondents to file a affidavit in opposition, which they have not filed yet. Kindly fix a matter on any specific date so that.
No file, not today. Okay. Next.
But I am for the respondent number 3, Union of India.
Who is for the respondent?
40 malad appeal. The item number 40 malad appearing of the respondent number 1, Union of India. Malad no copy has been.
Item number
40. 39 and 40 are malad similar. Will also kindly directed my petitioner to supply serve a copy of the.
You are appearing for whom?
Respondent number 1.
Item number 39.
39, 34, 40. In item number
40.
Yes.
Item number 40 you are appearing for?
Respondent number 1.
Respondent number 1, Union of India. Okay.
Main respondent number 3 and 4.
Which matter? Second matter.
Yeah,
5-1. Now that is the item number 40. So it is served. 9th March.
Only affidavit and copy of the affidavit reply has been served.
9th March. Affidavit of reply when what is the date of the affidavit reply?
Affidavit
Affirmation.
Date malad. Yeah. 16th of April. 16th of April.
So 9th of March you received the. Okay, give the copy. In which matter? 1595. What about the item number 1?
Item number 1,
No, the affidavit in opposition filed in the item number 1. There is a direction on 17th of March. After serving the reply, if any, within 1 week, 22nd April. And in this case, they filed the affidavit in opposition. Second matter? Affidavit in opposition है इसमें? No, there is no affidavit in operation. Record WP 26004 of 2025. In spite of the direction passed by this court dated 17 March 2026, the respondents have not filed affidavit in opposition. For the interest of justice, time to file affidavit in opposition is extended for a further period of 2 weeks from date. Reply, if any, there to be filed within a week thereafter. Full stop. In item number WPA number 5195 of 2026, Learned Counsel appearing for the respondent number 1 submitted he has not received the copy of the writ petition, but he has received the copy of the reply filed by the petitioner to the affidavit in opposition. Petition directed to serve the copy of the writ application along with the documents to the respondent number within 2 days from date. Full stop. Though the petitioner has filed the affidavit in reply, but there is no affidavit in opposition. Let the affidavit in opposition reply be kept with the record. List both the matters on after vacation. Matter on 18th May. Next. What is the age of the wife? Kindly come to the writ petition, cause title. See? Correct, no problem. Kindly come to the petition number 2. Where is the age? Then when the marriage was solemnized. Then and I can confirm it by kindly come to page 16. Page 16 at the bottom. As per ART law 2020. That is one. And petition number 2, this is the next page 30 my lord. Why at the bottom my lord, it says that why is 8 years, husband 4 years, 11 months, with a comment. ART law. Which page? Which page? Page 30 my lord. Wife age is 48 years. 3 months, 1 day. Husband is 54 years. Within the time limit approved, but the process that's why we are saying that we have to approve the code to get an order so that they can conduct this process. Right? So you're not having any child? No. Then? And come to page 37. The report of the 37? Yes. I know where it becomes. Not necessary. Where is the wife's report? That is required. Yes. Number 1 is that page 54. Date of birth 1/2/1971. Number identity card. Date of birth 20 October 1977. Yes. He is within the age. And only I am saying that this where is the judgment? Which judgment? You're not having the main judgment, wherein the virus has been decided by this court. Where is the act? एक्ट नहीं लाया ना आप लोग तो एक्ट नहीं लाया होगा. टाइम थोड़ी है आप लोग के पास. लो कोर्ट बंद हो जाए तो आप लोग ही बंद करके चले जाते. कोर्ट क्या बोलता हो तो जरूरत नहीं है. Record or not? The petitioner has filed the present application praying for a direction. Upon the which authority you had what is the prayer? क्या बोला? File the present application praying for a direction upon the respondent number 4. You are taking where you are taking the treatment? Where is that Ambuja Neotia? क्या बोला? Upon the respondent number 4. Upon the respondent number 4. To conduct assisted reproductive technology through IVF procedure in terms of the ART Act, ART within bracket Regulation Act 2021. Concept for the petitioners are the married couple and married in 20 years back. But unfortunately, they could not blessed with any child. Accordingly, the petitioners have taken a decision to go for the assisted reproductive technology through IVF procedure to conceive the child. Full stop. The petition number 1 and the petition number 2 have continuous under medical treatment, and after clinical and after conduct of the medical clinical test of both the parties, it was found that both the parties are fit to go for the IVF treatment, but the only hurdle for conducting the IVF treatment that the petitioner number 2, who is the husband of the petition number 1, is aged about 55 years. Is aged about 55 years. Police counsel for the petition submit that when the petitioners had been to the clinic of the respondent number 4, both the parties were within the age limit in terms of section 21 G, I and II of the Assisted Productive Technology Regulation 2021. But during the process, the petitioner number 1 has overaged. Petition number 1 has completed 55 years, and as such, the respondent number 4 directed the petitioner to obtain order from the competent authority to go for the further process of IVF treatment. Full stop. And full stop. Then concept for the petition submitted that as per the medical test conducted by the conducted in the clinic of the respondent number 2 and respondent number 4, comma, both the parties are fit to go for the IVF treatment, but only because during the treatment, comma, the petitioner number 1 has attained is overage, attained the more than the age of 55 years as prescribed under the 21 as prescribed under section 21G II, comma, the respondent number 4 could not conduct the IVF procedure. Land Council for the petition has relied upon the judgment in the case of Shamoli Shah and other versus State of West Bengal and others. A report filed in WPA number 23776 of 2024, dated 22nd/11/2024, and submit that in this case also the coordinate bench has consider that the husband was overage, but the Honorable Court has allowed the couples to undergo the IVF treatment irrespective of the age as mentioned in section 221G II of the Act of 2021. Full stop. Consider the submission made by the counsel for the petitioner, peruse the materials on record and the medical report. This could find that the respondent number 4 has duly certified that both the parties are physically fit and can proceed for the IVF treatment, but the hospital authority could not conduct the IVF procedure due to overage by the respondent petition number 1. Full stop. Assisted Productive Technology Regulation Rules 2022 provides for reasonable checks and balances. Full stop. A consent form is to be signed by the couples or the women disclosing their acceptance of ARTs. Full stop. The prescribed form we specified that there is no guarantee that the octis will be retrieved in all cases, comma, the octis will be fertilized, and even if there were fertilization, comma, resulting embryos would be a suitable quality to be transferred. The couple or the woman is made aware of the risk of the procedure involved. Full stop. There is no assurance that the pregnancy will be result in the delivery of the normal living child, and the uncertainty of the outcome of the procedure is fully explained to the couple or the woman. Full stop. As per the Act, commissioning couple means an infertile married couple who approaches the assisted productive technology clinic or assisted productive technology bank for obtaining the services authorized of the said clinic or the bank. Full stop. Gamete donor, GAMET, gamete donor has been defined as a person who provides sperm or octi with the objective of the enabling an infertile couple or woman to have child. Full stop. Patients has been defined as an individual or couple who comes to any registered assisted productive technology clinic for management of infertility. Woman has been defined as any woman above the age of 21 years who approaches the assisted productive technology clinic or assisted productive technology bank for obtaining the authorized services of the clinic or the bank. Section 21G of the Act bars the clinic from applying the assisted productive technology who does not meet the prescribed age criteria. In the instant case, comma, the woman falls within the prescribed limit, but the man is overage. Due to overage of the husband, the clinic is refusing to provide the service to the couple. The term patient in the Act permits an individual to avail the facilities of assisted productive technology irrespective of gender. The Act does not bar an individual partner of a married couple to avail ARTs independently. The same implies that the parties to a marriage may avail the service either individually or jointly. It is not necessary that the service has to be availed jointly by the married couple. There is no provision in the Act which bars the married woman to approach the clinical individually for availing the benefit of ARTs. The bar will not have any effect if the wife approaches the clinic to seek the service unilaterally. The clinic or the bank does not have any authority to refuse service of single partner of a married couple intends to avail the service. Full stop. Had the petitioner number one approached the clinic individually, the clinic could not have refused to provide ARTS to her. Here, full stop. Here, comma, since parties are the cordial relationship, comma, they approach the clinic jointly as commissioning couple. Commissioning couple, full stop. The central government has specified the reason for prescribing the age limit under 21G of the Act. As per data maintained by the government, comma, the age of the menopause of the female in India has been found to be 46.2 years. In this case, the wife has not crossed the said age. However, the medical report of the lady suggests that she is currently physically fit to hold the embargo by which embryo, which means the lady is eligible to avail ARTS both age-wise as well as the health-wise. Full stop. The legislature in the wisdom has prescribed an age limit to avail such services. The reasons for such prescription seems to be reasonably sound. In the absence of the proper restriction and supervision to check the defaults, there is very possibility that there will be a misuse and very purpose of providing such service will be frustrated. At the same time, the law cannot interpreted or applied in such a manner that the same becomes unworkable. Unworkable. Full stop. In the present case, comma, if the woman is allowed to avail ARTS citing 21G, even though she is eligible for the same, then it will be sheer injustice to her. For the ineligibility of her husband, the wife ought not to suffer. Full stop. This is so because the husband has no physical participation in any procedure involved in for the birth of the child through ARTS. The husband has claimed that he is financially strong. Full stop. ARTS. In view of the above, this court is of the view that the petitioners will be eligible to avail the facility of ARTS, and the response number 4 is directed to provide such facility to the petitioner if both the petitioners are to the petitioners in accordance with law. WP census disposed of. Next.
Lordship, I am for the petitioner. This is an innocuous prayer for consideration of an application made by the petitioner for the post of Muslim marriage registered at Kontai police station, Your Lordship. But the application was made on 19th of March 2026, but the same has not been considered by the concerned authorities.
Yes, who is appearing for you?
My lord, I am for the state. My lord, in this matter, my lord, we need the instructions, my lord, which we have asked for. We are yet to receive it. My lord, so far as my lord, the appointment of Qazi is concerned, my lord, it is, my lord, governed under the Qazis Act 1880. Now, my lord, the issue is that, my lord, the local populace of the Muslims, my lord, Mohammedan population, my lord, my lord, the requirement of the act is, if state government may, if it thinks fit, after consulting the principal Mohammedan residents of such local areas, select one or more fit persons and appoint him or them to be Qazis for such local area. My lord, this is factually, my lord, I have to take instructions what has been done.
The Qazi Act does not apply here because this is for the appointment of temporary Muslim marriage register. The Muslim Marriage Registration Act 1922 applies here, not the Qazi Act.
Either as it may, my lord, I will come back with instructions. Kindly permits me.
Land Council for the state prays for time to take instruction. According cases adjourned, let the matter appear on 14th May.
Grateful, my lord.
Next.
what happened was that this association was formed by the flat owners themselves. They applied under form the amount. The fortune comes. I'm for the developer. Now, there was some disturbance in the form.
What is your prayer?
I've accepted the form B has been submitted, competent authority in terms of the competent authority's direction. Now, there is a power of attorney, the person who has submitted form A, he had given a power of attorney from which it appears that he is authorized to submit it on behalf of majority of flat owners. Now, subsequently, form B has also been given to him. Now, what we have been, competent authority is asking for a fresh power of attorney, which authorizes that person to submit the form B. Now, that person who's one of the flat owners is now no longer cooperating. Now, there is already an order which says that all parties agree that the form A is required to be amended. That order is at page 304, passed in terms of an earlier order of this honorable court, which is at 297. 304, my lord, can you see? This is the competent authority's order. And our court's order is 297. Second paragraph. The documents of the demand for necessary amendment in debt is to accept it is exists in accepted form A. The association also accepted the proposed amendment.
Where from you are reading?
I'll page 304. May I just place this? In compliance.
No, that is first and second. The total High Court is part in order.
Second paragraph, this authority heard the parties and examined the relevant documents that substantiate the demand for the incorporation of necessary amendment in declaration exists in accepted form. The association also accepted the proposed amendment.
Correct.
Now comes to my lord, the last paragraph. In view of the above, the parties are hereby directed to initiate the process for amending the declaration already accepted by this authority in the prescribed manner as laid down in the West Bengal Apartment Ownership Act and rules framed thereof. So subsequently, Form B, which is like an amendment to Form A, is done by Form B. That is also submitted before the competent authority.
When it was submitted?
Yes, the acknowledgement is that acknowledgement of Form B.
Page 306.
306.
Form B under the West. Yes, so you are submitted. Then what has happened?
Now, the thing is that now, and this person who has submitted the Form B, he has to submit a document saying that he has been authorized.
Where is that?
So this is something we have come to learn, and we have been writing to the person that you please submit. Now the person is saying that he's no longer interested, he's no longer cooperating. The person, because he's one of the flat owners, no longer cooperating. Now the authority is also not proceeding to accept the form or amending the form. But then Form B has been submitted by the same person who has submitted the form. Consent has been given. It's a consent order that yes, amendment is required. An association, the initial order of our High Court is that the Form A itself was.
So what do you challenge?
This is exactly the authority has. There is that the Form B which has been submitted, that the authority accepted, because acceptance of Form B is a mere formality after the entire procedure. Even the power of attorney which has been I'll show my lord the power of attorney that the person is at page, and this is volume 1.
No, that will come see. In terms of the order passed by this court, the authorities already passed an order.
Authority
correct. Accepting your Form A.
Now.
Correct.
Yes.
Accepting your Form A. The association also accepted the proposal of amendment. Now, in view of the above, the parties are directed to take initiative process for amending the declaration already accepted by the authorities in the prescribed form as laid down in the Form B.
No, that has been also submitted.
So you are submitted at page 306.
Yes.
So it is pending.
It is pending. Now, authority has
so who is the authority to consider this?
The competent authority under the apartment.
Who is?
Number 2.
Yes.
My lord, what I have come to learn from this writ petition, my lord, the person who has filed the Form B is not coming to the honorable court.
Either you reject it.
Now, let there be a hearing of this considered Form B be considered. Let representation may be considered by the authority, my lord. that Form B.
It's already there.
Form B, let it be considered, my lord, because what section 10, my lord, section 10 says, my lord, after submission of the Form B, my lord, there is a process, my lord, which has to be carried on, my lord. A notice has to be issued, a hearing has to be done.
Correct,
So
correct.
let that process be continued.
That's why you have to conclude the
But I-
proceeding. Either they are not coming, then you pass expert. If they are coming, then you
My lord,
dispose
my
of.
My lord.
In a time-bound manner, my lord. Can you make it time-bound?
That can
Because
be done. That can
304,
be
they have already, there's a decision that yes, amendment is required.
That can be done.
As appearing for the respondent number 4, who is the president, although I had a preliminary objection with regard to the maintainability, since the association was not made parties to this
Association, possibly I can't because
the
Just a minute, just a minute. Yes.
Form A was accepted by virtue of the order of the 17th of January. The association should have been made a party, but the president in his individual capacity has been made a respondent number 4. And the allegations of respondent number 3 not cooperating does not stand, my lord. We have actually we have actually supported their contentions that they have submitted the Form B on our behalf. And the portal which was created, my lord will kindly see from the application, it has been name of the applicant, page 306, name of the applicant is Shaktiboda Bhattacharya, who was the earlier applicant by virtue of the special power of attorney. We have corroborated with them. No, we have no qualms with regard to the, if the proceedings continue under section 10(2)(a) for the hearing of the form.
You are appearing for whom?
Respondent number 4 and 3.
3 and 4. So they are the
private
respondent number 3 was the earlier special power of attorney holder who has submitted the Form B as well, and respondent number 4 is his individual capacity, is the president of the present association.
But they're supporting the case of the petitioner.
I'm effectively supporting, but their contention with regard to the association not being in existence as of today, that part I'm objecting to. Because they have,
because it has been set aside.
because the Form A was accepted, but if there is no suit, my lord, how can I amend the plaint? I have by order of 17th of January,
the competent authority, if they say that they have been authorized to submit Form B, that can be recorded.
They have already submitted Form B. Let a hearing be done under section 10(a) to upon notice to all the side. One more thing I'd like to point out, there's an election to be held in the last week, third week of May. If it can be done before that, so that the election may not be halted.
But that is not the issue over here.
No, that is
for that they have to file a separate rate.
No, my lord, it is in our contentions. My lord will kindly see. That can be done in the time-bound manner so that the election can be held in May. That much I'm praying for, Your Lordship. My lord will kindly see page 311, which is the letter issued by the association.
311.
311, my lord. My lord will that's the letter issued by the association, my lord. In bullet 311.
So who is the writ petition now? Is the association?
The developer. I am the association.
Oh, you are the developer.
Yes. I am the association effectively, but not been made a party.
Fortune Park, okay.
Page
Both
3.
are fortune.
Yes. Association's letter, my lord, paragraph number 4.
The holding of election is not the subject matter of this.
But fact remains,
because otherwise
let that be done in a time-bound manner. That's what I'm praying.
Okay, I am simply directing the who is the competent authority.
Let that be done in a time-bound manner so that the election may not be halted. That much I'm praying, my lord.
I am not recording any election. I am only recording with regard to the order passed by this court earlier, and the authority passed an order. Now, if file this Form B, form is pending before the competent authority. Competent authority is directed to take appropriate decision after giving an opportunity of hearing to all the concerned parties.
Within a time-bound.
Within a 4 weeks or 6 weeks.
I'm great. That much. I'm great.
That I am not touching your election and all these things.
No, not with regard to election. Election and their contention with regard to non-existence of the association as on the date.
On the earlier round of litigation, this court by an order dated 1st of December 2023 in WPA number and WPA number 25143 of 2023 was disposed of by passing the following order. Page 302, paragraph 24 and 24 and 25. In terms of the order passed by this court dated 1st of December 2023, the Special Secretary and competent authority has passed an order on 17th of January 2024. Pass the following order on 17th January 2024. Page 304. After the order dated 17th of January 2024, comma, the petitioner has submitted, and the one Mr. Saktipada Bhattacharya, respondent number 3 has submitted Form B to the competent authority, but till date, the competent authority has not taken any decision after receipt of the application, after receipt of Form B, and the same is pending before the competent authority. That is our respondent number 2. Considering the above, this court find that no purpose should be served of keeping the writ petition pending. Accordingly, the respondent number 2 is directed to take appropriate steps with regard to acceptance of the Form B submitted by Mr. Respondent number 3 by giving an opportunity of hearing to all the concerned parties within a period of 4 weeks from the date of receipt of this order, and to pass an appropriate order, pass a reason in a speaking order. Full stop. As this court has disposed of the writ application at the motion stage and not called for the affidavit in opposition, the allegation made in the writ application deemed to have been within 4 weeks from the date of receipt of the order. Leave is granted to the petitioner to correct in the cause title with regard to the district in course of the day. Granted to the petitioner, advocate on record of the petitioner. Next. Nobody is there. Nobody is there, not today. Since appearing for the petitioner, none appears on behalf of the respondents. Counsel for the petitioner submit that in spite of the direction passed by this court, no affidavit in opposition is filed. In view of the above, for the interest of justice, time to file affidavit in opposition by the respondents is extended for a period of 2 weeks from date. Reply, if any, there to be filed within 2 weeks thereafter. Full stop. List the matter on 11th of June 2026. Full stop. The petition is directed to communicate this order to the respondents for compliance. Next.
But for the petitioner,
yes.
Well, here the petitioner and his wife, my lord, settled in India in 1992. Thereafter, in 93, my lord, their son was born. Well, the son was granted a valid passport, my lord, in 2013.
But where is the other side? Nobody. Not today.
Well, not today, will make it in the monthly list. It will retain its position.
Not today. That's why come on the next. It is a daily list. No, it is not the monthly list.
I think my lord, Monday is the monthly list. That is why.
Daily list नहीं आएगा ना. At the top करो. वो ये उसी में करो within 10 minutes करो. Yes, next.
But I'm for the state response.
Well, Mr. Prantik Ghosh is appearing for the petition.
Yes.
For Mr. Prantik Ghosh is appearing for the petition. I'm praying for not today, my lord.
Not today. Further notice. What is the matter? Yes.
My lord, kindly fix another day, my lord. And kindly fix another.
Whether
I'm not,
court is having determination.
my lord, I'm
Jilla
not,
Parishad and
my lord, I'm
Panchayat.
not brief in this matter, my lord.
Okay, it's not brief in the matter. It is before the senior. As per the prayer made by the council for the Jilla Parishad, let the matter appear on 6th. As per the prayer made by the petitioner, the case adjourned, let the matter appear on 6th. Next.
Yeah, my lord, I am seeking for 1 day's accommodation.
Not today. Next.
Eight, my lord, I appear for the petitioner. My lord.
Which was the respondent?
You know, on the last occasion, my lord had directed me to serve once again and come back. But I have served. If my lord will remember, Mr. Gupta was arguing the matter on the last occasion. I indicated to my lord that no intimation of freezing, no reason, why frozen,
Of?
freezing, why
Who is
the
appearing for
account,
the respondent? Here.
the
What is the
reserve.
instruction?
Yeah, Mr. Gupta.
Yes, what is the instruction? Okay.
But we are.
Who is for the bank? AU Small Finance. Who is there?
They don't appear. Kindly sees the last order also.
Yes.
They don't appear. They need not appear, it seems. But
So
we
where-
are covered by judgments of high courts all throughout the country, which says this blanket freezing of bank account.
Where is the freezing?
But they have not informed anything. I can't even show from my writ petition. They have not informed anything which is in black and white. Kindly says my writ petition is devoid of any annexures per se. I have only given my fixed deposit account and my current account which had that money. May I just indicate in 1 minute my facts? But I had a fixed deposit of around 4.75 crore. With that fixed deposit, I have taken a fixed deposit overdraft account. So, in my overdraft account, I can withdraw the money, but they have the security of the 4.75 crore. They suddenly freeze my overdraft account. So, but the interest which is being generated, I am unable to replenish that. So, I have the risk of my account getting NPA. Despite me having money with them. But they do not inform us what is the freezing order, what is the quantum, nothing. My account is simply inoperational, that is it. That is not even being, we are not even being shown as to where is the freezing order or for what quantum.
That's why how you can say how you can say the freeze, where is that's why
But the Reserve Bank of India is saying that they have filed a complaint. I don't know.
No, who filed the complaint? You filed the complaint.
But I have filed a complaint.
Here
I have
this
been
is that
informed.
you made a complaint, but before the 30 days you invoked.
Yes, yes. Now my problem is I have not been indicated in black and white by the bank that my account is frozen. I have been informed orally. I write to the bank. There is no response. So, what would
I'll just assist my friend because otherwise, on the merits of the matter, when we lodge the complaint, we close the complaint on the aspect that they did not approach the concerned banker who had acted upon some freezing order or whatever, on the basis of which the account was frozen. Now, the documents which have been disclosed in the petition, if the lordship kindly turns to page number 39 once, because 40 is the complaint.
No, 38 is to the bank.
38 is to the bank,
Bank.
39 is to the bank.
Yes.
39, if I look into, They say that if your lordship kindly looks into the first few lines of that account.
We had requested.
Requested you repeatedly, but you had not done this from your end. Also, you have not given proper reply to us after requesting several times for mobile calls and several times to your branch. All your replies have been evasive. On one instance, you informed us verbally that our account is debit free. However, the bank statement of the said account shows that the account is regular. When asked about the same, we were informed that you would get back. You would get back to us regarding the status of the account and execute our request at the earliest. However, it appears that all the repeated requests and constant follow-ups are falling to deaf ears as the matter is just being procrastinated from your end on some pretext or the other just to buy time. Please note that we are incurring interest on the OD account continuously, which is causing a financial burden to us. Now, pausing here for a moment, what they are saying is correct, that they got to know orally from the concerned bank that their account is frozen. What they was required to do was, on getting to know, they ought to have approached the grievance redressal mechanism prescribed under the Fair Practice Code of the RBI and should have approached the concerned banker then and there, writing that how their account would be frozen, because the complaint which they ultimately lodged to the banking ombudsman on the following page, your lordship will find, they are challenging the account being frozen. But such challenge ought to have been the first resort is the, like we always know that in case of a problem, they first lodge a complaint with the police. Similarly, in this kind of a case, the first complaint is lodged with the concerned banker, that how the account is turned as frozen. So on that basis, my lord, they ought to have approached bank because they did not.
This is the page 39 is to the banker only.
It is to the banker, but your lordship will see that they are not alleging or they are not bringing in any application on the aspect that as to how their account would be turned as debit free. The complaint is absolutely different. It is stated that they have been asking for bank statements from the accounts, etc., and which will be also corroborated from the previous page. That is page number 38. That premature or FD held with your bank against your FD, OD account, etc., So these are the complaints, but not with regard to freezing of account. They are saying we have come to know about freezing of account, but they had to lodge it with the concept because there is a prescribed mechanism. You have to follow it. And within 30 days after waiting.
But problem is that these are not appearing before the court.
Yes, now they are not.
So I am directing the police authority.
Today there is a resolution, I believe next day.
No, even last day, last day's order. Then there was no resolution. I have once again served.
But today there is a resolution. I'm just
But only one submission, my lord, reacting to my learned friend's contention. It is possibly not the law, and I am backed by judgment.
Whatever it is, now the court is with regard to the court has issued the notice, they should come.
Yes.
They should come. Then they.
Looking to Reserve Bank integrated.
That is correct. That is correct. He has to meet. But once if the parties find that the authority is not giving any response to what the
Can I
party
do?
will
Well,
do.
only one other thing, one submission. Possibly, I am not required to go to an ombudsman, and I have not gone to the ombudsman. It's only a letter written to Reserve Bank of India. I have not lodged a complaint with the ombudsman. A. B is, my lord, possibly I am not required to follow this for the only reason the law as laid down by the different high courts of the country, including this court,
That's I'm telling.
is that account cannot be blanketly frozen.
In spite of several notices issued to the respondent number 2, the respondent number 2 failed to appear before this court. Accordingly, the petitioner is directed to serve the notice to the concern, which is the police station. Which is a concerned police station?
Only one thing. One thing. I should place this. Kindly sees this email we have received on 6th April from the bank. The bank has informed that there is no debit freeze and the funds lien has been marked earlier in your account basis the notice received from basis scriber sign complaint. But they say, but the bank has said that there is no debit freeze. Yet they say that some notice has been received from
cybercrime complaint. But my account is still unoperational. They do not give any complaint, but it is only on, this is the only letter, communication I have received after filing of the writ petition. Recently we have received.
क्या बोला?
এটা দিয়েছি ইন্টারেস্ট লাগবে না আমাদের অ্যাকাউন্টে দিচ্ছে না ফিক্স করে দাও
Fail to appear before this court. Full stop. The petitioner has handed over an email dated 6th of April 2026 issued by the respondent number 2 to the petitioner, wherein it is mentioned that inward comma we wish to inform comma you that comma the inward comma no debit inward comma close and funds lien has been marked earlier in your accounts basis the notice received from inward comma basis cybercrime complaint inward comma close. Full stop. Though the bank had the knowledge with regard to the writ petition filed by the petitioner, but in spite of the same, the bank is not appearing. According, petition is directed to serve the notice through the concerned police station with the PS
Bidhan Nagar Melod North.
Which PS? Through the officer in charge police station.
But we'll kindly keeps it blank, my lord. I shall indicate. My lord.
Officer in charge, Bidhanagar police station, whatever it's and the officer in charge is directed to file the report on the next date fix. It is made clear that on the date fix, if the respondent number 2, respondent 1 or 2, 2, if the respondent number 2 failed to appear before this court, comma appropriate order will pass. List the matter on 7th under the same heading within 10 matters.
I'm sorry.
Sent to banking ombudsman. The two of them.
Okay, I will decide on that day. I am not deciding today.
Yes.
Otherwise, they will take.
They will say
that
no adverse order.
I've also handed over one circular by which the bank cannot charge interest during the period when the account is frozen.
But
Okay.
Bidhan Nagar North.
Bidhanagar North, huh?
I'm so grateful.
Great. In neither.
You saw the notice along through the concern.
49 I beg to appear on behalf of the petitioner. Affidavit service to the what happened here, my lord? I have a bank account with the respondent bank, and thereafter, my lord, I opened fixed deposit, my lord, to the bank, state bank. My lord, after opening the fixed deposit, the bank suddenly, my lord, credited my fixed deposit to my savings account, and thereafter, my lord, we transferred the amount to the third party without my consent, without any sharing OTP, and thereafter I lodge a complaint before the cyber cafe, cyber lodging center, and bank and RBI. Meanwhile, the police authority, my lord, recovered 91,000 from the one account, but other remaining, my lord, amount, the bank, my lord, showing the shadow credit to my savings bank passbook. Shadow account, shadow credited means, my lord, temporary kept in abeyance, and that will be disbursed subsequently. But till date, no step was taken by the bank concerned as well as RBI, because the bank under the RBI will take action against the bank. Why without any? I did not, my lord, share any type of, my lord, OTP or any SMS to the bank concerned, and bank, my lord, totally liable for this fraud.
Yes. Yes, who is for the bank?
My lord, I beg to appear for the Reserve Bank of India, my lord.
Who is for the bank?
State, my lord.
State already recovered.
Who is for the bank? Which bank?
My lord, that is my Ujjivan Bank.
Huh?
Ujjivan Small Finance Bank.
That is the scheduled bank.
USFB.
Ujjivan Small Finance Bank.
Ujjivan. Small bank. Have you served?
Yes, my lord. I put a detail. I will service. Bank receive it.
Yes. But today is the bar resolution. None counsel for the petitioner, counsel for the Reserve Bank of India and the state are present, but none appears on behalf of the respondent number 2. Full stop. The petitioner has filed the affidavit of service. Let the same be kept with the record. The petition is directed to inform the next date of hearing to the respondent number 2 and to file the affidavit of service. It is made clear that on the date fixed, if the respondent number 2 failed to appear before this court in spite of having the knowledge of the date of hearing, the writ petition will be taken up for hearing in the absence of the respondent number 2. List the matter on 13th May.
I did.
Much obliged, my lord.
What is করা?
আমি আমার কাজ করি
91 to recover হয়েছে।
Yes.
Yes. But I am for the state in this matter.
Who is for the petitioner?
Seems what is it?
Not today. Kai, hamar block करता है. Yes.
51, my lord.
Where is other side is there?
My lord, I am for the income tax department, my lord. No, this, I am for 51. 51.
50?
51, my lord.
Ah.
Well, this is a case with regard to where I am seeking cancellation of Aadhaar cards, PAN cards of my husband, my lord, because apparently with regard to the FRRO report, they are Bangladeshis, my lord, residing in India based on certain opt-in.
Who is happening for the private respondent?
My lord, that's why I wanted to indicate, my lord, they have not been added as a party. Kindly grants me liberty to add them as a party, my lord.
Who are they? Wife?
My lord, the husband, the mother-in-law, the father-in-law, my lord, the entire family, they are Bangladeshis.
Have you made a complaint to the authority?
Yes, my lord, at page 59, my lord, 59 and 64. My lord, I have made.
Their name has been included in the voter list.
Yes, my lord. Yes, my lord. My lord, the mother-in-law is living in India on a valid visa as on date, and her name is appearing in the SIR list, my lord.
Counsel for the petitioner prays for leave to add the husband, mother-in-law and father-in-law.
And the husband, my lord.
Mother-in-law and husband as party respondent in the incident.
And also, my lord, the brother-in-law, four my lord.
Husband, mother-in-law, father-in-law, and brother-in-law. Brother-in-law. Full stop. The petition granted leave to add the said persons as party respondent in course of the day.
Yes, ma'am.
In course of the day, and to serve the copy of the writ application along with the writ its annexes to the added respondents within a week from date, and to serve the and to file affidavit of service on the returnable date. List the matter on 14th May.
Your Lordship, the amended cause title may be served upon us.
The day before yesterday, my lord, I mentioned on that day it was 74, 75, today it is 70, 71. Injunction is still today.
Still?
Till today, my lord.
Okay, I will come before I
think my lord is my lord.
I will. Okay, 70. Because I may reach, this court may reach 74. Please wait. I will come at 2. Before rising, I will allow you.
My lord,
On
today,
this
my lord.
I was submitting that my learned friend is not there.
My lord.
The other side is not here today.
Which matter?
70 and 71.
Where is our last order?
Last order was 7th April.
Where is the last order? You're not having the order.
No, I am having one. Kindly allow me, my lord.
Yes.
My lord, today, my lord, there is a distribution of the bar, my lord. My lord, I was not able to, my lord, attend my lord on serial number 14.
My lord, may I be permitted to mention a matter, my lord?
there and these matters will take some time. Two matters are there fixed.
You persons are not understanding.
I'm sorry, my lord, I'm sorry to both of them.
Which serial number?
That's 7071.
Both.
Matters.
7071, huh? And though the matter is listed as item number 70 and 71 of the today's list, but the learned counsel for the same could not be taken up for hearing due to paucity of time. Counsel for the petition mentioned the matter and submitted the interim order still today and paid for extension of interim order. In view of the submission made by the counsel for the petitioners, the interim order is extended till 24th of June 2026 or until further order whichever is earlier. Let the matter remain in the list.
I'm deeply.
Yes, call the list.
Well, resolution is passed, my lord, the serial number 14, my lord. July. 141 to 155 to 161. And
My matter will not continue, but it can be, my matter will not continue, small point, but this can be adjusted.
Good. Okay, I will pass out. Yes.
Just a small indulgence, Lord. My matter was also tagged in the connected matters. It's not reflecting the causes today. I'm just applying the case details.
Let I have not called the matter.
Right, we'll come back.
Please, I will take the matter. All matter I will take. Let the urgent matter be taken first. Which matter?
76.
Huh?
76.
76 it will not reach today. I cannot say you check the diary, you check the cause list and you can come. That's why if you wait, if the other side will be there, then I'll fix a specific date. Please wait, we'll see to that. Yes, sir.
Sir, kindly come to, my lord, kindly come to page 27.
Who is appearing? Mr. Chaudhary, you are appearing?
Yes.
Yes.
Page 27, my lord.
Yes.
First of all, my lord, page 27, kindly see, this has been given yesterday. Although it was 13th April, it was given yesterday. In view of the apprehension expressed from various quarters, we do not know the quarters, regarding possible irregularities during the process of counting votes. Irregularities during the counting is in your hand. How can you say the irregularities? With a view to ensure transparency, the order conduct of counting process, the following protocol and are proposed for strict compliance. At least one among the counting supervisor and counting assistant at each table shall be central government / central PSU employees. I am challenging this one, clause 1.
Yes.
Now, it is issued from the office of the Chief Electoral Officer. Kindly come to page 28.
Yes.
Who has signed additional Chief Electoral Officer, West Bengal. My first point is, it is beyond the jurisdiction.
Yes.
First point is beyond the jurisdiction.
Yes.
Lord,
then
first, my lordships, kindly come to page 47. This is a page 34. This is a handbook for counting agent, page 34. Kindly similar 1.3. The following persons can be allowed inside the counting hall.
Page?
Page 34.
Yes.
Counting supervisors, counting assistants, and micro observers.
Clause?
Clause 1.3.
1.3. Yes.
Counting supervisors, counting assistant,
and micro observer.
These are already appointed long back.
Yes.
Then 2 persons authorized by the ECI. ECI means Election Commission of India. Possessing authority letter duly issued by the ECI and observers. Therefore, any other persons, if the central candidate employee have to be taken, this has to be authorized by the Election Commission of India. Then public servants on duty in connection with the election. Whoever not involved with the election, all of a sudden you are bringing them as in the counting. You are not there. Even the public servant has not been codified under the Representative People's Act and the rules framed there under. Then if the central government is a public servant, I take it, Millard. Central government is a public servant. Then he has to be part of the election process. Who was not part of the election process, he cannot be done. He cannot be brought. He cannot be brought.
So as per this 1.3, these are the persons who can continue to be in the counting hall.
Now, Millard, kindly kindly come to page 47. (9.11).
Yes.
Apart from one counting supervisor and one micro observer for each counting table, one micro observer would be seated in each of the 14 counting table. The micro observer will invariably be central government PSU employees. There were only the micro observers.
Yes.
That is accepted.
Yes.
The micro observer will note down and details of the exhibit by the EMS being counted in each round as so and so. Now, there is no scope of the central government employee to be brought as counting supervisor.
Counting supervisor and
counting assistant.
Counting assistant.
Only in case of micro observer,
Yes.
one micro observer. Now, let kindly see the Election Commission of India, Article 324, Sub-Article 2 of the Constitution.
Yes, 324.
324(2). The election commission shall consist of the chief election commissioner and such number of other election commissioners, if any, at the president may from time to time fix, and the appointment of the chief election commissioner and other election commissioners shall subject to the provisions of any law made in that behalf on parliament so and so. Therefore, the election commissioner has been defined. Effectively, I tell you, Lord, says the chief electoral officer role, chief election of electoral officer, the losses will not find any act. What is prescribed? That is not the returning officer, assistant returning officer, and election commission. Chief election commissioner has no power to issue any directions.
Yes.
324(1), kindly see. The superintendent's direction and control of the preparation of the election rolls for and the conduct of all elections to parliament and to the legislature every state and election to the office. Control supervision is vested with the election commission, not with the chief electoral officer.
Yes.
And Millard, your lordship knows, Millard, the principal B.S. Binasta আছে বার করতে পারবে বিশুরু B.S. Binasta বার করো 84(2). The B.S. Binasta case, the lordships have gone that if procedure is fixed, you have to go by your procedural law. Whether it's a guideline or whether you are saying that it is your guideline. Election Commission guideline. The beyond the Election Commission guideline, one cannot pass. Even the Millard. Just 1 minute, Millard, kindly give it. I will just. Well, these are the main points. I will just show 1 or 2 paragraphs. Kindly come to paragraph 16.
So how you are affected?
It is central government employee. If it is beyond the jurisdiction law, then I have to say what has happened yesterday. There are points which I have raised in the one of my petition, which was dismissed here, and the Supreme Court has said, because of the paucity of time, we are not in a position to decide, because entire returning officer, etc. But Supreme Court has said, these are all important questions of law has been decided. We are keeping it open. The question is, if the returning officer is appointed, just I am taking, in complete violation of law. Why the central government employee? Why you are insisting on central government employee who is not involved in any election process? I can understand, my lord, the CISF, CRPF for the law and order. That's all right. They are taking it. I am not on that. Returning officer, who will be the returning officer has been defined. Returning officer at the level of the subdivisional magistrate. Subdivisional magistrate of a state.
Correct.
Everybody has been defined. Assistant returning officer has been defined. Counting supervisor, etc. has been stated. All are state employee. Why you are bringing central government employee? More, your lordship is saying why I am prejudiced. In itself, in the complaint itself, it has been order itself. It has various corners. From whom you have got it? Particular one political party.
Okay.
Whether it is a particular to one political party, who are that? Why did you not disclose? Because there are meetings are held. Why did you not disclose? These are the complaints are coming. All of a sudden you can't say that. And 60, latest appears to be on 60th April. The 60th April, what you have presumed? Irregularity. You are saying the irregularities. If you apprehend, kindly read page 27 again. In view of the apprehension expressed from various quarters. In which quarters? Where is the writing? If it is writing, why you have not disclosed it earlier? We have to deliberate. What type of? Regarding possible irregularities. During the process of counting votes, do you disbelieve the state government employees? Entire election you have done with the assistance of the state government employees.
So whether they have already appointed the counting or this counting supervisor, counting assistant.
Counting supervisor, the original counting supervisors have been appointed.
No, that's why. Original, leave aside this order. Before this order,
Yes.
Any
But who are the counting supervisors? Let me tell you, lords. Who are the counting supervisors? In various levels of the election, your lordships will find returning officer, presiding officers, micro observers, not only from the central government, state government is also there. So many observers there. And all are state government employees. So far the observers are concerned only from the central government. But in the main election process, let's take it, Millard, from the presiding officer. Presiding officer. Who are assisting the presiding officer? They are all state government. Returning officer, state government.
Correct.
DRO, state government. Everybody is state government. Now, to remain in safe, then you delete observer. Why the observer? When the observers are there, who are the central government employee?
Okay.
And paragraph 16 I am showing to your lordships. Kindly come to me, Lord, paragraph 16. The petitioner is unaware of any similar notification having been issued by the in any of the other 4 states. Why the state of West Bengal you are taking discriminatory attitude? Below 2,500 companies have been brought here. If one company was at Pahalgaon, these 26 persons were not killed.
Let's not go into
No.
From yesterday we are hearing. Let's not get into all of that. Let's stick to the law.
I am sticking in the law.
Yes.
Yes, I am sticking in the law.
Let's stick to the law.
Yes.
I personally don't want to go into any of this. I just want to show from the, I'm appearing for a statutory body.
I will not finish.
No, no.
Here also you will not give the right of hearing. You don't give the right of hearing anywhere.
Now,
You
this court will give.
no. He
In a conference.
He means his client.
His client.
He means not he.
Milord,
His client doesn't want to hear anybody.
Milord,
Don't worry, this court.
I know. Milord, that is the reason we are. Otherwise, would have been wiped out long back.
Milord, let us.
Right from here to Supreme Court.
Milord, he gets a right of audience in a conference with Mr. Banerjee and has got so for 20 years.
Yes.
His client may be at loggerheads. Once he finishes, I'll be not.
Loggerheads, if you say, then I will have to show.
You are filing a writ petition.
Loggerheads, if you say loggerheads, yes, the loggerheads. What you have done to us, yes, I have filed a petition, I was present there. Get out. Don't say, Mr. Chaudhary, don't open your mouth too wide. Don't move. Just 1 minute, Milord. Give me one thing. Yes, my BS Binas case, 1983, volume 4 SCC. Page ta koto? Starting from? Judge, page ta bolo na, okay, to citation ta dite hobe. 582. My lord, kindly see the paragraph 23. Judge Joseph ke bar kore. Read out. The next question that arises for consideration is whether the appointment of respondent number 4 as director of respondent number 1 is illegal because of non-compliance with bylaw 2 so and so. In the instance case, it is admitted on both sides that no publicity whatsoever was given in respect of the vacancy. The contention of Sri Gorg, however, is that the bylaw having no force of statute, non-compliance with its requirement cannot in any way affect the appointment of respondent number 4. They cannot say that is no statutory effect. They are saying is a constitutional power has been given to us. Just contrary.
Here is the constitutional effect.
Huh?
Here is the constitutional effect.
Constitutional, the guideline itself is similar. Is a power which has been given by the constitution.
That's right. That's why he is having the constitutional effect on that.
Effect on that. This, however, contended that assuming that the bylaw is not a statutory, even so, respondent number was found to comply in support of this content. It is well settled rule of administrative law that an executive authority must be rigorously held to be standard by which it professes its action to be judged, and it must scrupulously observe those standards on pain of invalidation of an act in violative of them. This rule was enunciated by Mr. Justice Frankfurter in Vitellus Return, where the learned judge said an executive agency must be rigorously held to the standard by which it professes its action to be judged. Accordingly, if dismissal from employment is based on a defined procedure, even though generous beyond the requirement that binds such agency, that procedure must be scrupulously observed. This judicially evolved rule of administrative law is not firmly established, and if I may add right so, if that he that takes the procedural sword shall perish with the sword. This is line. The apostle principle so and so is applicable in India, so and so quoted in so and so. Now, interestingly, not for this case also, remember, if in view of the point of this code on the point of transfer, if the bylaws have been framed for the conduct of it to avoid arbitrary, cannot therefore escape the liability for not following the procedure. Compliance with this bylaw also seems to be necessary in the name of fair play.
If the vacancy.
Fair play in action is required.
Yes.
If the fair play is not there. But these are my arguments.
Thank
you. The long and short of it is under, my lord, if your lordship sees, my lord, the returning officers handbook, clause 15.7.9. I'll just show it, my lord, from this. That we've sent for a photocopy. Please see, my lord, 15.7.9.
What is this?
My lord, this is the
handbook of
returning officers handbook.
Yes.
Counting 15.7.9. It's, my lord, detailed as to who's to do, my lord, counting. Please see 15.7.9.
Yes.
Counting staff appointments should be made in the form given in Annexure 35. Counting supervisors should preferably be gazetted officers, Group B or above. Counting assistants should also be Group B or at least Group C officials of the central or state government or officers of comparable status from central or state government undertakings. All appointments have been made in the procedure under this.
List the last line.
Yes.
Officials of the central government or state government.
Yes.
Or officers of the comparable status
From the central or state government undertakings. So, my lord, it is central/state government.
Correct.
My learned friend's argument is, why is it from the central government? Answer is, it is permitted by this. Law mandates.
No. Counting staff.
Yes.
Appointments should be made in the form given in Annexure 35.
Yes.
Counting supervisors should be preferably by the gazette officer first.
Yes.
That's the first
Yes.
criteria. Gazette
Should
officer.
counting supervisors should preferably be gazetted officers,
That is the
Group B
first
or above.
criteria.
Yes.
Correct. Now second.
Counting assistants. Lord, I'll read it for your lordship. Lord. Counting assistants should also be Group B or at least Group C officials of central or state government or officers of comparable status from central or state government undertaking. So, long and short of it, either officials of central or state government or officers of comparable status from undertakings of central or state governments. This is, my lord, the law.
Okay.
ECI, my lord, has made appointments exactly in terms of this.
Okay.
One political party cannot, my lord, come and complain that the wisdom of ECI's appointments is wrong. Please see the writ petition. What is the complaint? My lord, please come to, my lord, page 37. This is the only legal argument. I'm sorry, it's not 37, 34.
Yes, 34.
Yes. 34, section A. This is the only document, my lord, shown.
Yes.
What is the argument? My learned friend showed, my lord, section A1.
Yes.
And, my lord, in particular 1.3.
Correct.
And says following persons can be allowed inside the counting hall, which means any of the categories mentioned thereafter duly authorized.
Yes.
Now, appointments have been made under 15.7.9, read with, my lord, the relevant notifications, and they, my lord, will be entering and doing it. So, my lord, there is no difficulty at all. What is his argument? My lord, shorn of everything else. The argument is, how can you exclude state government officials from appointment? My lord, that is, my lord, the domain of the election commission. Whether, my lord, the law permits appointment of either central government or state government officials. So central government officials have been, my lord, appointed. It is not for one political party to come and, my lord, tell, my lord, the...
But
Yes.
subject to,
Yes.
okay, you have shown the law. Subject to, if there is an objection by
Yes.
central government, can the election commission cannot adjudicate? Yes, okay, central government, state government, why you're not going for this state government also?
My lord, that is the wisdom of the election commission.
I
To,
am
my
that's
lord,
why I'm
avoid
telling-
any form of
that's why-
allegations.
That's why I'm telling, if a objection is raised with regard to some person.
This is not an objection with one person.
Okay,
This is
suppose.
objection with regard to a class.
Okay, one class.
One class.
One class. And
Yes.
that class, he is not asking the class which is not in the law. Not in the law.
Correct.
Correct.
Yes,
Not
this
in
is
the law.
permitted.
It is permitted.
Permitted.
If it is permitted, why the adamancy by both the parties?
We've already made appointments, countings on
That's when-
Monday.
when the appointment was made.
My lord, appointment was They have been made, my lord, on.
That's why I wanted the first question I put to Mr. Banerjee when the appointment was made.
Yeah. Sir, after my lord, I don't have the exact date, but it's already been made because counting, we are on Thursday. Tomorrow is 1st May holiday. Counting's on Monday.
Correct.
And counting, my lord, your lordship will appreciate what the only argument, my lord, is that persons authorized to do the counting are not authorized. I show your lordship, they are authorized. My lord, this is not a place for, my lord, sentiments of one political party. It's, my lord, a judicial scrutiny. I'll come to the second aspect, my lord, of maintainability. It's, my lord, a question of judicial scrutiny of, my lord, discretion exercised by the Election Commission in respect to the process of elections. Yes, if it was wrong, your lordship, my lord, possibly can say it's wrong. Your lordship is a constitutional court. But, my lord, this is not wrong. It's state or center. Not employees. So central government employees have been selected. So, my lord, there is nothing wrong shown. It's not an act done contrary to statute.
Okay. Next.
My lord, now, my lord, please have a look at the writ petition. No, Galagal. My lord, I am not, my lord, I am here to argue legal points. My lord, please have a look at the not the basis of the petition. Kindly, my lord, see paragraph 6. My lord, this is what the petitioner, my lord, showed your lordship.
Yes.
Then, my lord, 13th April 26, notification. Then, my lord, paragraph 8. Petitioner is the main opponent, which admittedly runs and controls the central government.
Yes.
And then, my lord, well known that the central government, my lordship sees, my lord, paragraph 8. My lord, I'm not reading it because, firstly, my lord, it's contentious. Secondly, my lord, I don't want to read it. It is well known that central government PSU employees would be directly under the control of state government and are likely to be susceptible.
Central government.
Yes. My lord, please see this. It is obvious and well known that the central government, central PSU employees would be directly under the control of the central government and are likely to be susceptible to the suggestion and control of persons in the BJP. Such direct control of BJP over the central government, central PSU employees gives rise to an apparent risk of bias, influence, partisan conduct during the process of counting of votes. In comparison to the number of central government such and such, there is no identifiable state government employees who may be present in terms of the handbook of counting agents. So therefore, this is arbitrary or without jurisdiction. So the basis of the petition, my lord, there are three, my lord, important issues which, my lord, the petitioner would have to establish to get orders. Number one, a central government employee would be directed to commit illegality in an electoral process. A whole class of persons are susceptible to illegal conduct because they are central government employees. Secondly, the central government, whether the government or it's the PSU, would, my lord, give illegal instructions and have, my lord, votes counted at elections in an illegal manner. The highest form of illegality. This is the second presumption. The third plank is that a political party.
No, what the central government and PSU can give an
illegal instruction. This is the basis, my lord, of the paragraph. And this is the only, my lord, this is the plank of the petition. That A, the person counting would do illegality. He is a central government employee, but he'll do illegality. He'll, my lord, rig counting of votes. Second presumption is that those at the helm of the central government or of the PSU would, my lord, give illegal instructions to these persons to, my lord, rig counting of votes. And third is, my lord, a political party at the center would, my lord, have all-pervading control over all central government employees who have been asked to, my lord, count votes through, my lord, those in command of these, my lord, PSUs or, my lord, government departments for this illegality to be, my lord, pervaded. Now, all of this is presumption and not something your lordships, my lord, in the absence of material, because your lordships, my lord, proceed on the petition. Your lordships see material. If there is material, your lordships, my lord, come forward to do justice, to ensure, my lord, that justice is done. But, my lord, paragraph 8 proceeds on presumption.
Yes.
There is no material to persuade your lordship that this state of things can happen.
Yes.
Now, my lord, please see paragraph 10. The aforesaid, my lord, this is the notification. And then, my lord, handbook of counting agents. And then arbitrary. That's the end of it, really. And please see paragraph 20. This is a classic.
Paragraph
20.
Yes.
The immense ratio of central government representatives is likely to create an atmosphere of fear, intimidation, and coercion amongst other individuals present at the counting table. Where is the material to show this? Why this presumption? They are also government employees. The state government employees are also government employees. The Election Commission, my lord, in its wisdom, have, my lord, chosen a set of central government employees to do this job.
Yes.
So, my lord, point number 1, if I may repeat up to now, point number 1 is that there is no legal basis for the petition.
Yes.
I have referred to, my lord, 15.7.9 of the Returning Officer's Handbook. There is no legal basis. Now, second submission is there is also no factual basis. I have shown the petition to show that this is on a perceived notion of, my lord, the world being against, my lord, the petitioner. And this honorable court, my lord,
Totally objection.
no,
you
don't
can't say
object. This is your
No.
petition.
World being means what do you say? What
I am proceeding on
No,
your petition.
Said,
Mr. Bandyopadhyay,
No, Mr.
I respect you.
Sorry.
I will not shout at you.
No, I am not that.
You are
World
getting
means
worked up.
Mr. Chaudhary. Please,
I am on
please
the
make-
basis.
Make
You
your
got the
legal and whatever the fact.
No, I am,
Not what is the petitioner, what is the response. Please.
my lord, I am proceeding on the basis
Yes,
of the
yes.
petition.
Yes, tell me.
The petition says, makes these allegations, and my submission is there is no material to suggest this.
That I have taken note of it.
That's my submission. Number 2, there's nothing else there. So no legal basis, no factual basis. Now my third legal submission. My lord, please have a look at Article 329 of the Constitution. Last 2 weeks we've been showing this article, my lord, in large number of times.
I'm happy that the Election Commission is trusting on Article 329. First time.
Yes.
Last 2 months we are, my lord, this 4 months, including Supreme Court. They said 329 is subject to 324. Nothing is 329. But I am happy today they are saying 329.
Yes.
I remain, my lord, unflustered. I have a lot of respect for Mr. Bandyopadhyay. I've acted as his junior.
But I have to say that.
I don't want to get into this. So what am I doing? You are interrupting. I am arguing.
Giving lecture.
My lords, I also appear for Election Commission of India. My lords, my turn may also come a little later. My lord's permit.
No, I am for the CEO, my lord, West Bengal. Mr. Naidu, my lord, is for the Election Commission of India. My lord, I'll be very brief and leave him, my lord, to deal with, my lord, the Constitution. My lord, we are relying on 329. And just one statement, because I know Mr. Naidu will be arguing the law on this, so I don't want it to be replicated. He will, my lord, deal with this aspect of the matter. I just want to create two, my lord, distinctions to all the other cases, my lord. Number one, your lordship said, my lord, that this is when we, my lord, other matter, that this is an administrative matter. So I have to see. But this is not an election matter. Who counts the votes?
But
your lordships.
But kindly read the 329B.
Yes.
Can this will go to the election petition? You satisfy me, I will pass an order herein now.
No,
if this,
of course this
if
can.
This type of the matter.
Of course this can. Of course, my lord. What is why not, my lord? May I just put this to, may I put a situation? Say, for example, in, my lord, a particular state, there is, my lord, some anomalous condition found with respect to counting of votes. That is, my lord, a cause for challenge to the election results. Of course it can go. And the distinction, my lord, is between this example, which I give your lordship, and, my lord, a situation of, my lord, motorbikes or, my lord, the other matters which have come before your lordship. This is directly in the heart, my lord, of the election process. Secondly, my lord, alternative submissions, Article 226. Your lordships have said, my lord, Article 226 last minute in these matters is not to be lightly entertained. And, my lord, I'll request Mr. Naidu to, my lord, make the rest of the submissions on law. In case I have some extra judgment, I'll show your lordship at the end.
Okay. Yes, Mr. Naidu.
May it please, my lords.
Yes.
My lords,
Yes, my lord, I'm sorry, Mr. Naidu, just one sentence.
Yes.
By 27th of April 2026, counting personal appointments were all done. That's what, Lord, my instructions say. By 27th April 2026.
27th April?
Yes. We were on 30th. It was all done. Okay. Your lordships wanted a date?
Yes.
Lord.
When the Mr. Bhattacharya, when this letter was issued?
Which one?
13th April, but it was given only on yesterday. We have said so. No meeting, it was disclosed. Kindly come to Milord, page 10. Paragraph 22. And not a, Milord, which is not written here, or not written here. Not, there are meetings are being held. Not any single meeting, Milord, it has been disclosed. Regular meetings with the political parties are being held.
Yes, Mr.
May it please, my lords. With regard to the observers, this issue was raised earlier, and that was negatived by the learned division bench of the Calcutta High Court. They have taken that to the Honorable Supreme Court, and there the Honorable Supreme Court has refused to interfere with that order. but it has left the questions of law open. I am given to understand the petitioner's contention is, since that question of law has been left open, we can re-agitate even before the Honorable High Court, seems to be the gravamen of the argument. May I just take your lordship to that judgment minutes, which was rendered very recently. Identical plea was raised. I'll just read a couple of paragraphs and then I'll take my lords to whatever that's material as far as the statutory provisions are concerned. In the judgment, my colleague would supply minutes, the division bench judgment. Has it been supplied to your lordship's minutes?
Yes, yes, got it.
Kindly see minutes. Para 7. Para 7 of the judgment.
Yes.
Section 20B of RP Act of 1951 is relied upon, and it is contended that observer has to be from the same state. Much emphasis is laid on the word government used in Section 20B. By taking this quote to the dictionary meaning of the government from Black's Law Dictionary and Article 20 of the Constitution, he submits that the word government means the concerned state, which in the present case is state of West Bengal. Article 367 of the Constitution and Section 3, subsection 23 of General Clauses Act were relied upon to submit that the word government used in Section 20B must be read as state government, that is government of West Bengal in the present case. Sri so-and-so submits that the ECI may place reliance on certain handbooks and manuals issued by it, but no such guideline can prevail over the Constitution and the summary provisions ingrained in Representation of People Act 1950 and 1951. My lords may kindly come to page 19 and para 34. Para 34 minutes.
Yes.
So-and-so learned counsel for the ECI reiterated its stand and placed reliance on explanation appended under Section 20B of the Representation of People Act 1951. It's urged that this explanation negates the contention of so-and-so, learned senior advocate, that observer can be appointed in the same state to which he belongs. For this purpose, he also placed reliance on Section 3, subsection 23 of General Clauses Act to explain that definition of government includes central and state governments both. Would my lords come to para 38 minutes? Para 38.
Yes.
On a careful reading of the petition in general and para 28 in particular, leaves no room for any doubt that petitioner has not disputed the existence of power with ECI to transfer, shift the officers after issuance of election notification to ensure free and fair elections. My lords have seen. Then my lords could come to para 40. Page 24, bottom minutes, para 40, 40.
Yes.
In the instant case, it's clear like noonday that petitioner has raised eyebrows because sizable number of officers were transferred by ECI. In view of the aforesaid pleadings, where existence of power of ECI to transfer shift offices is admitted, we are not inclined to conduct any roving inquiry and analysis to examine whether the ECI otherwise had any such power or not. Then their lordships went on adjudicating all issues and have said that since you have not questioned the vires, the power of the Election Commission of India, they have got all the discretion and the power well within their purview, being a constitutional body, to conduct elections in fair and transparent manner, the way they deem it proper. For that purpose, especially the issue of observers, has not found favor with the Honorable Division Bench as far as the petitioner's consent. The same petitioner, or rather the petitioner supported. It is another PIL that's been filed before the Learned Division Bench. This is one thing, Millets. Now I deal with the issue with regard to Millets, whether the question of law has been left open. Does that mean, in my humble submission, the judgment that's been rendered stands obliterated so that everything gets reopened even at the level of the Honorable High Court? Could my Lord see, Millets, I just read one sentence from the order dated 16/4/2026, the Supreme Court's order. It must have been there, Millets.
Yes.
Could my lord see, my lords, though the petitioner has raised some substantial questions of law which might require consideration, however,
Yes.
keeping in view the election schedule in the state, we are not inclined to entertain the special leave petition. My lords may kindly appreciate, my lords, at the threshold, there is a refusal to entertain the SLP. That means the next sentence, the special leave petition is accordingly dismissed. My lords, as far as Article 136 is concerned, unless the Honorable Supreme Court goes into the merits of the matter, the doctrine of merger does not apply. So the first premise of my submission is that, my lords, the judgment rendered by the learned division bench of the Honorable Calcutta High Court stands firm as far as the Honorable Calcutta High Court is concerned, and it is the precedent for co-equal and other benches.
Yes.
Only the third paragraph, my lords, could see. However, the question of law is kept open.
Yes.
That means, my lords, as far as the Supreme Court is concerned, perhaps whenever the occasion presents itself, it may consider that one and rule on that one. But as far as the judgment that's been rendered, refused to be interfered with, stands firm vis-a-vis the Honorable High Court. That's why, my lords, it can't be heard there saying, no, it's been completely opened up and that got obliterated. The very dismissal of the SLP speaks volumes about that, is my humble submission. Then, my lords, let me come to the...
Then you clarify in the paragraph 3, however, the question of law is kept open.
Yes, my lords.
This kept open because a special leave petition is dismissed. So that special leave petition is not before the Honorable Supreme Court to decide the question of law. Now the question of law is kept open. So who will decide the question of law?
The question of law left open vis-a-vis the Honorable Supreme Court. My lords, the question of law has been left open for the Supreme Court to consider in some other case. But as far as the Honorable High Court is concerned, that is the law that binds until it is interfered with by way of a subsequent judgment. Because,
So,
my lords, first,
so in this regard, whatever that is to be challenged, that is to be challenged in the SLP only. Not
no,
by
my
the
lords,
Supreme
my
Court
lords,
or before the
my lords,
appellate.
I'll submit, my lords, what has happened, if at all, an issue has to present itself. As far as any high court is concerned, my lords, other high courts, it is only persuasive.
Mr.
Yes,
Naik,
my lords.
appreciate
Yes,
your submission. Yes, the point raised by the petitioner in the appeal that has been dismissed and that has been upheld by the Supreme Court. I totally agreed with that. Okay,
Indeed,
this cannot go into that. Okay, I appreciate to that effect. But once the paragraph 3 has come, however, the question of law is kept open. If it is kept open, so this court and the division bench have hands are tied, so we cannot decide the issue
my
further.
lords, in my humble submission, that is the law. In my humble submission, that is the law. Once the Supreme Court under 136 has refused to interfere, then the doctrine of merger does not apply. The judgment stands undisturbed and its presidential value has not been robbed. But the occasion...
So what about the paragraph 3? Who will decide the issue? Kept
my
open.
lords, that has to be decided by the Honorable Supreme Court. It's been left open for the sake of the Honorable Supreme Court.
And in which application?
Any time, my lords, a similar issue comes before it, it will decide that one. As far as the High Court is concerned, my lords, as far as the High Court, my lords, it's the usual practice in Supreme Court. It's the usual practice in Supreme Court that we all mention. If the Supreme Court is not with us,
with regard to division bench order, Supreme Court order, dismissal, there is no ambiguity.
Absolutely.
Yes,
there is no ambiguity.
Yes.
Yes,
but
my lords.
now the paragraph 3, the question of law is to be kept open. If it is kept open to whom? Only to the Supreme Court, and Supreme Court already dismissed, so they cannot.
No, in a subsequent matter.
What's been said, my lords? My lords, what's been said?
Larger bench of the Calcutta High
My lords
Court.
may kindly see what's been said, why they have not examined. First paragraph, my lords could see. Though the petitioner has raised some substantial question of law, which might require consideration, however, keeping in view the election schedule in the state,
Correct.
they have said this is not a fit case to examine that one. So we are not interfering with the judgment, and that judgment remains.
Okay.
When the occasion comes, we may examine. That's how the option has been.
Okay.
That's why, my lords,
Then the other
judgment
way around, DB
died.
judgment stays.
That stays, absolutely. This is my humble submission, my lords. So that has not been diluted. That's not been diluted. Even a co-equal division bench is bound by the judgment. That's what my lords have had many a time when it comes to certainty, judicial discipline, these things are the ones. Now let me come to the statutory parameters, my lords.
Yes.
Could my lords take, my lords, the Representation of People Act 1951?
Yes. And you will not adhere to. Huh? Huh? তবে senior counsel অন্য
Yes.
ওটাও চলে যেতে পারে।
Which section?
Let's kindly come to 1951 Act, Section 19, capital A.
Section 19,
A, capital A minutes.
capital A, yes.
Delegation of functions of Election Commission.
Yes.
The functions of the Election Commission under the Constitution, the Representation of the People Act 1950, and this Act, or under the rules made thereunder, may, subject to such general or special directions, if any, as may be given by the Election Commission in this behalf, be performed also by a Deputy Election Commissioner or by the Secretary to the Election Commission. This, my lords, have seen the power of delegation as far as the other authorities are concerned. Now let me come to, my lords, Section 20, capital B.
Yes.
Before that, may I just take your lordship to Section 20 as well. 20, general duties of chief electoral officers.
Yes.
Subject to the superintendent's direction, my lords, got it, means?
Yes.
Direction and control of the chief electoral officer, the district election officer shall coordinate and supervise all work in the district or in the area within whose jurisdiction, in connection with the conduct of all elections to Parliament and the legislature of the state. The district election officer shall also perform such other functions as may be entrusted to him by the Election Commission and the chief electoral officer. Now let me come to 20B minutes, observers.
Yes.
The Election Commission may nominate an observer who shall be an officer of government to watch the conduct of election or elections in a constituency or a group of constituencies and to perform such other functions as may be entrusted to him by the Election Commission. The observer nominated under subsection 1 shall have the power to direct the returning officer for the constituency or for any of the constituencies for which he has been nominated to stop the counting of votes at any time before the declaration of the result, or not to declare the result if, in the opinion of the observer, booth capturing has taken place at a large number of polling stations or at places fixed for the poll or counting of votes, or any ballot papers used at a polling station or at a place fixed for the poll and are unlawfully taken out of the custody of the returning officer, or are accidentally or intentionally destroyed or lost or are damaged or tampered with to such an extent that the result of the poll at that polling station or place cannot be ascertained. My lords, see subsection 3, where an observer has directed the returning officer under this section to stop counting of votes or not to declare the result, the observer shall forthwith report the matter to the Election Commission, and thereupon the Election Commission shall, after taking all material circumstances into account, issue appropriate directions under Section 58A or Section 64A or Section 66. Explanation. For the purpose of subsection 2 and subsection 3, observer shall include a regional commissioner or any such officer of the Election Commission as has been assigned under this section the duty of watching the conduct of election or elections in a constituency or group of constituencies by the Commission. In fact, my lords, even the Election Commission of India staff could be the observers, and this is the sweeping power that's been conferred on the Election Commission and its discretion, my lords. This is how. Now, my lords have also asked a pertinent question with regard to the bar under, I'm just coming to that one, my lords, 329B. My lords, it's been many a time referred to your lordships, put before your lordships' kind consideration. Now, let me take section 100 of the same act. Section 100.
100 of
RP Act 1951 minutes.
Yes.
Could my lord see minutes? Grounds for declaring elections to be void.
Yes.
Subsection 1, subject to the provisions of subsection 2 of the High Court, the High Court is of the opinion, my lords could see D, kindly see D minutes, that the result of the election, insofar as it concerns a returned candidate, has been materially affected.
Correct.
Next, Millets, kindly come to clause 4.
Yes.
By the non-compliance with the provisions of the Constitution or of this Act or of any rules or orders made under this Act.
Correct.
That's why, Millets, if anybody has any grievance that Election Commission has not followed the rules and it has conducted itself in holding the elections or the counting, whichever element of, my lords have seen many a constitution bench of the Supreme Court has said election should be expansively interpreted from the date of notification till the declaration of results. It should be read as election. That's what M.S. Gill has said and many other judgments have said. Now, Millets, my lords may kindly see, this is one election dispute that could be raised. That's why squarely 329B attracts. Then the second aspect, my lords may kindly see. This very notification was issued on 13th April 2026.
Yes.
And it was in the public domain.
Yes.
Millets, had there been any grievance on the part of any person, it would have been challenged on time. And they're feigning ignorance. Millets, in every other case, even before the ink could dry on interdepartmental or intra-departmental, very confidential communication, they could place it before the Honorable Court within a couple of hours and agitate saying that one. You could never question how I got that one. You only have to say whether that is correct or not. This is what the plea all along. Now, for the first time, they feign ignorance and say, I come to know about this one very recently. The logic is simple, Millets. Monday is the election. Today, if there could be any introduction, Millets, we cannot have the composition again set right. Then essentially counting could not take place. Then that results in postponing of the whole process. That's how 329B comes into picture. Millets, when it comes to conducting of elections, Millets, my lords have said, even when an MRO office was shifted by the government, somebody questioned, no, that should have not been the Panchayat office, to be precise. That is not the suitable place. This is the place. Court said that they've enjoyed the power under Article 162, and then they have got the coextensive power with the legislature. Then how could you dictate every term? That's why they've just thrashed it out. Here at my lords may kindly similars, they wanted to breathe behind the neck of the Election Commission, saying that, no, you should not stand, you should not sit, and you should just conduct elections as I please. And they could not succeed. My lords may kindly appreciate, last 3-4 months, ever since the SAR has begun, dozens of applications, dozens of petitions have been filed before the Honorable Supreme Court, including with regard to returning officers, including micro-observers. They could not succeed anywhere. Then, Millets, they have gone before the Honorable High Court of Calcutta. There, they've raised all these pleas in a PIL. Again, they've lost. And now their only fig leaf is that, Millets, since the question of law has been left open, I can re-agitate. Kindly visualize, Millets, the mammoth task that's been there before the Election Commission. And then, with no time, if at all, Millets, I need to contradict, I need to place my material, Millets, I need to have my counter put in place. I may be requesting your lordship for reasonable time to come back with my defense, and that has to be placed. Then your lordship may do that something on the merits, whichever way, Millets. Then either party could have their remedy with regard to any aggrieved, if they are aggrieved, Millets. Now, my lords may kindly see every time.
That's why a specific question was put to you with regard to
Yes,
the paragraph 3. If you are telling that if this court will give time to file affidavit and all these things, if this court will give time to file an affidavit, so what the question? It is up to the Supreme Court. So what purpose would be served by keeping the petition pending?
Yes, Millets. Millets, but the difficulty is this, Millets.
That's why you're telling that you will bring all the things on record. If you bring all the things on record, and this court will not able to pass an order because the matter is kept by the Supreme Court only. So what the writ court, this court will do now?
Minutes, I submit, it's been there for a while. The date I mentioned, well, at 13-4, if they wanted a remedy, they could have come on time. They've not done that one.
That
They
I
have
think.
chosen this time. And Millets, in this case, my lords have asked what is the value of the question of law left open, Millets. What's the judgment this is? 22 of which judgment? One moment, Millets, I may be kindly forgiven.
When I want to cite a judgment.
Please,
If Mr. Naidu doesn't cite.
Millets, this is Millets. 2024 SCC Online Delhi. Could my lords kindly, this is the division bench judgment, Millets. 2024 SCC Online Delhi 8805.
44?
Millets, one moment, Millets. This is page number 8805. I may be pardoned, Millets. 2024 SCC Online Delhi 8805.
Yes.
My lords got it, Millets?
Yes.
Let me read the proposition. In this one, Millets, para 22. Para 22 of this judgment, Millets.
Yes, yes.
On the presidential value of the judgment of the High Court, when the civil appeal preferred thereagainst is dismissed by the Supreme Court, leaving the question of law open. This court had an occasion to observe recently in SSC versus Darpan Sharma as under. On the implication of a question of law being left open by the Supreme Court while dismissing an appeal or a special leave petition, a division bench of the Honorable High Court of Gujarat in Collector so-and-so ruled as under. When the Supreme Court records that the question of law is kept open, undoubtedly it's meant to be considered in future by the Supreme Court only. The question of law, as correctly contended by Sri so-and-so, is not kept open for the High Court.
Okay.
This is precisely what was held and observed by the division bench of this court in an unreported decision in so-and-so, where in full agreement with the view expressed therein, it was a case where an issue so-and-so, so-and-so. Miller, this is what the law in my humble submission.
Thank you for that.
I'm grateful, Millets. I'm grateful for the opportunity.
If Mr. Naidu is finished.
That's Mr. Anything further, Mr. Naidu?
I've read it. No. I've read 20. Yes. I beg your lordship's pardon, Mayor, I'm getting instructions because I've just been briefed just a while ago.
Any further? Any further submission?
I think my friend will supplement, Millets.
Okay. One judgment.
Millets, I'm grateful for the opportunity. I thought, Millets, it was curtains yesterday, not to be so.
The reason I stopped is A, my learned friend is senior to me. B, I don't want to waste the time of the court. So if there's something which he wants to say, I shouldn't repeat it. Lord, please have a look at this judgment. This is what I got a copy. Lord, have I handed up Lord, multiple copies to your lordship? No, I'm sorry, Lord. This is 1982, volume 2 SCC, page 218.
Yes. Yes.
Lord, please have a look at the first paragraph. The transferred case and the appeals connected with it raise important questions. Paragraph 1, Millard. The transferred case and the appeals connected with it raise important questions which require a careful and dispassionate consideration. Hearing of these matters was such and such, judgment will take some time. We propose to state our conclusion on some of the points involved. Now, please see 1. High Court acted within jurisdiction entertaining writ petition and issuing a rule nisi because since the petition questioned the vires of the law of election, but with respect, it was not justified in passing the interim orders dated such and such and in confirming those orders by its judgment dated such and such. Firstly, the High Court had no material before it to warrant the passing of those orders. The allegations in the writ petition are of a vague and general nature on the basis of which no relief could be granted. Secondly, though the High Court did not lack the jurisdiction to entertain the writ petition and to issue appropriate directions therein, no High Court in the exercise of its powers under Article 226 of the Constitution should pass any orders, interim or otherwise, which has the tendency or effect of postponing an elections which is reasonably imminent and in nature and in relation to which its writ jurisdiction is invoked. The imminence of the electoral process is a factor which must guide and govern the passing of orders in the exercise of the High Court's writ jurisdiction. The more imminent such process, the greater ought to be the reluctance of the High Court to do anything or direct anything to be done which will postpone that process indefinitely by creating a situation in which the government of a state cannot be carried on in accordance with the provisions of the Constitution. India is an oasis of democracy, a fact of contemporary history, which demands of the courts the use of wide statesmanship in the exercise of their extraordinary powers under the Constitution. The High Courts must observe a self-imposed limitation on their powers to act under Article 226 by refusing to pass orders or give directions which will inevitably result in an indefinite postponement of elections to legislative bodies, which are the very essence of the democratic foundation and functioning of our Constitution. That limitation ought to be observed irrespective of the fact whether the preparation and publication of electoral rolls are part of the process of election within the meaning of Article 329B of the Constitution. We will pronounce upon that question later on. Then, my lord, paragraph 2, the second paragraph. It takes years to build up public confidence in the functioning of constitutional institutions, and a single court hearing perhaps to sully their image by casting aspersions upon them. It is the duty of the courts to protect and preserve the integrity of all constitutional institutions which are devised to foster democracy. And when the method of their functioning in question, which it is open to the citizen to do, courts must examine the allegations with more than ordinary care. The presumption, be it remembered, is always the existence of bona fides in the discharge of constitutional and statutory functions. Until that presumption is displaced, it is not just or proper to act on preconceived notions and to prevent public authorities from discharging functions which are clothed upon them. We hope and trust that the charges leveled by the petitioners against the Election Commission, the Chief Electoral Officer, and the Electoral Registration Officers will not generate a feeling in the minds of the public that the elections held hitherto in our country over the past 30 years under the superintendent's direction and control of successive election commissions have been a pretense and a facade. The public ought not to carry any such impression, and the voters must go to the ballot box undeterred by the sense of frustration which the petitioner's charges are likely to create in their minds. We see no substance in the accusation that the voters' list have been rigged by the election authorities with the help of enumerators belonging to any particular political party. Enumerators are mostly drawn from amongst teachers and government servants, and it is difficult to imagine that 35 years after independence, they are totally colorblind. They are the same in every state and every constituency. The safeguard lies in the efficiency and impartiality of the higher officers who have to decide objections for voters' lists, etc. So, my lord, this also went from Calcutta. The writ petition was dismissed.
Yes.
Now, my lord, just one sentence regarding the judgment, my lord. One paragraph I wanted to show from this judgment. My learned friend, my lord, relied on the next paragraph. My lord, please take page 14 of the judgment. Oh, I'm sorry, my lord. My lord, page 21, paragraph 38.
Yes.
Lord, paragraph 38 is identical to the situation before your lordship. Petitioner has not disputed existence of power with ECI. Here also, he's not disputing the existence of power to appoint central government employees. His argument is that no, you also should have employed state government. Leave the ECI to do that, to do their job. The presumption is they're doing it correctly. And the fact situation is they're doing it well. There's been unprecedented voting. Now, my lord, next paragraph. In the writ petition, the petitioner needs to plead and prove his case. Here, my lord, there is no pleading. There is surmise that, my lord, central government employees will, my lord, do something wrong. He has to prove his case. Now, my lord, I'll very quickly, my lord, point out some judgments to your lordship from the compilation, which I will refrain from reading in great detail because they've been read before your lordship, my lord, multiple times over the last few days. But I just take names of the judgments and, my lord, stop. My lord, on the my lord, at a Kolanda, a copy down. What is this? My lord, I'm sorry, I should have. Didn't strike me. This is what I cited earlier, and this is the compilation. Thank you. The compilation is to division. Same division here, all that judgments are distinct. Yes, that's why I am not wasting court's time. My lord, please, my lord, take, my lord, I'm citing, my lord. Compilation টা দিয়ে দিয়েছি প্যারাগ্রাফ গুলো বলে দিই। হ্যাঁ তাই এখানে আছে তো। এক্ষুনি করবে। না তোর স্ট্র্যাটেজি কি শেষ করবি? না, I have no strategy.
No, my lord, when Mr. Chaudhary has been engaged by the election commission, so he thought that this court should be continue till 5 o'clock.
No. It's only 10 past 3 and I'll take just 1 minute, my lord.
I like him in the dining table. I don't like these things in the hair.
Yes.
He is a very good.
My lord,
he selects the menu very nice.
My lord, I'll tell your lordship at the end of the day, Mr. Bandopadhyay is a senior I've worked with for 20 years plus, and I've really enjoyed working with him. We've had some brilliant times in Delhi doing company matters. And one day, my lord, we'll both tell your lordship the experience.
Sometimes
outside, but only one sentence. I take pride and joy in being the first person to introduce to cod, which is a wonderful fish.
Oh,
yes.
If my lords forgive me, millets, only one sentence I'll add with my lords kind leave, millets.
Yes.
Yes, we were caught off guard, millets. We have to fish for something and place it before your lordships, as my learned friend has correctly said, millets, a constitutional institution that enjoys presumption of correctness and something has to be hurled it, there should be some basis, millets. For that purpose, what's been said by the Honorable Supreme Court way back in 1982, millets, the judgment is 1982 2 SCC 218.
1982?
So that's the one
Millets,
I read.
1982 2 SCC 218, my friend must have. Just one sentence my lords could see, millets.
I read it.
Kindly.
I also saw, I'm sorry. I'm sorry,
Beg your pardon.
Please continue.
Yes, millets, kindly come to para 2, millets, in this judgment. We are unable to accept the argument advanced on behalf of the petitioners. My lords could see, millets?
Yes.
We are unable to accept the argument advanced on behalf of the petitioners that the Election Commission or the Chief Electoral Officer or the Electoral Registration Officer have in any manner acted in violation of the Constitution, etc. The second paragraph, my lords could see. It takes years to build up public confidence in the functioning of constitutional institutions. My lords got it?
I have taken note of it. Mr. Chaudhary has
Yes,
already.
and millets, and also that above paragraph, millets, para 1, subparagraph 1, it's been said, the imminence of elections must also be a factor to be taken note of once the Honorable High Court is exercising its powers under Article 226. It's not a question of imminence, millets, in my humble submission. It's the middle of elections, and elections are over.
Thank you.
And millet, now they would like to upset the apple cart, millets. That may not be permissible. And my lords have seen the scope of 329B, millets, which has been said. And millets, I'm not troubling your lordships. We have already had a compilation with regard to 329B that will be handed over to your lordships, millets, with paragraphs marked.
Okay.
Grateful for that.
Sentence. This is directly election. Number one. Number two, last minute Article 226 order would have the effect of actually preventing elections from concluding. And that's all, my lord. I stop there. Yes.
Lord, first of all, my learned friend's submission. I did not want to tell that he has opened his mouth, therefore I have to speak. First of all, submission is that the vague, correct? Kindly come to page 27. Which order is challenged? I have read it, but sorry, my lord, I am just.
Yes, it's no problem.
In view of the apprehensions, he said, writ petition is on the basis of the apprehension. Apprehension is the basis of the order of the impugned. And from various quarters regarding possible irregularities. What that possible, my lord, the quarters regarding possible? 1 hour, the argument has been made by the Election Commission. They could not produce a single document. From whom? Therefore, this 45, my lord, my statement made in paragraph 8. You are working for only one group, one political party. Can you read paragraph 8?
Yes.
Everything is vague. The foundation of the order is vague. Give the details. His case is that I am apprehending. Therefore, writ petition is liable to be dismissed. Therefore, he is on the apprehension. Therefore, order should be set aside.
Yes.
And you are conducting election. Nobody. You are conducting election. You are saying that votes are with a view to ensure transparency and orderly conduct of counting process.
Yes.
Now, my lord, my second submission is, my lord, the returning officer handbook is not with us. What you have given to the candidates handbook. Returning officer, it is yours. Returning officer, it is yours. Handbook of the to the candidates, that is for everyone. Therefore, what you have written, that is not written. In your drawer, it is there or not. That is not a not the. I am not required to sue. Even then, when he has relied upon, then a returning officer.
বার করে দেবো ওটা?
হ্যাঁ দাও একটা আমাকে দিয়ে দাও, এটা আমি নিয়ে চলে যাবো।
এটা পাওয়া যায় না এমনিতে?
না পাওয়া যায়, কেন তোদের অফিসে পাওয়া যায়, আমাদের কাউকে দেয় না এটা। আমাকে কেউ কেউ ভালোবেসে দেয় সেটা অন্য কথা, তাদের পাওয়া যায় না। দেখি কোন প্যাকেট কোনটা দেখালি। হ্যাঁ, নাও সি 15.7.9.
Yes.
Counting staff appointment should be made in the form given in Annex 35. Counting supervisors should be preferably by gazetted officer Group B or above, comma. Counting assistants should also be Group B or at least Group C officials of the central or state government. Therefore, only the counting assistant has been allowed, not others.
No, first line, the counting supervisor.
Counting staff appointment should be made in the form given in Annex 30. Stop. Counting supervisors should be preferably be gazetted officers Group B or above, comma.
Counting assistant.
Counting assistants should be also be Group B or at least Group C officials of the central or state government or officers of cooperative.
Of the central and state government.
This is only case of a counting assistants.
No, comma. Counting supervisor.
Comma, counting assistants. Yes. Counting assistant, not the others.
Okay.
Not the others.
Yes.
Right? Now, my lord, see, it has been said above the judgment earlier. What was the challenge in the? It was not touching with the counting. What was challenge in that? They have not said so. He was reading the judgment, taken 15 minutes to read the judgment. What was the challenge? Challenge after the transfer of the returning officer. Returning officers were transferred. Police officers were transferred. That was under challenge. That was under challenge. Here, counting has not been taken place. That time when the process of appointment of the returning officers had been done, that order was challenged.
Yes.
Police observers appointments were challenged. Already appointed and they are working on.
Correct.
Counting has not yet been taken place. And there is, during election, no holidays. Whether it's Saturday, Sunday, Monday, nothing.
Yes.
Nothing. Second, my lord, kindly see. Last, my lord, third, not last. Do you see? I want to hear this argument from Mr. Naidu in Supreme Court. Not here. You will.
Well,
You will
my friend and me, we always meet in Supreme Court and he's welcome once again.
This is the argument I want to hear, that only Supreme Court only hear the point of law, not any other court. Let him speak of that.
Yes.
This argument that this point of law only will be asked in the Supreme Court. I wish to hear this argument from him in the Supreme Court. Now, though through the petitioner has raised, though the petitioner raised substantial question of law, which might require consider, however, keeping in view the election schedule in the state, we are not inclined to entertain the special leave petition. The special leave petition, however, the question of law is kept open. Although there is, see, the question of law is kept open. To whom to decide? To whom this can be decided by any appropriate court.
Yes.
Therefore, the merger issue, etc., doesn't arise here. If it is a plain simple dismissal of the writ petition, a SLP, then I can understand. And see, why did not interfere? Because already schedule is there. If schedule is there, why the change of game, policy of game in the midst of schedule? See, when the order was passed, according to the, although we have got it, 13th April, notification was 7th or 9th March.
Correct.
7th or 9th March, whatever the law was there, whatever is there, already nomination has been completed.
7th March only notification.
Before 16th April, 13th April.
Yes. That
nomination completed by 9th April.
Correct.
Why you are changing the rule of game? It is not an action, it is a policy decision. How can you do it?
Yes.
Why my petition was not accepted? Because schedule has been declared. Right?
Yes.
If the schedule has been declared, why this memo? How can you change it?
Yes.
But the question is not that the appointments have been made. Question is it illegal?
Okay.
Whether whatever the phase you have, whatever the consequences may be, it is not a matter that one day you can appoint it. After election, it is not you are enjoying holidays in your home. Give a declaration that no, from today after 5 o'clock, nobody will work. Give it. The problem is that, I am a man of the field. I am a man of the field. Now, he said that the superintendent power of the Supreme Court, power of Election Commission should be respected, etc. In West Bengal cases, power of Supreme Court, power of Election Commission has been curtailed. Lordship knows that orders have come to your Lordships. That first adjudication will be done by the judges. This is the power of the election. Why? Supreme Court has done it. Then appeal tribunal has been made. Of course, that is a 30 years. We have now 75 years and 78 years. When we have come across so many cases, then the Supreme Court is curtailing the power. He has shown these judgments.
Well, it's your lordships have always appreciated one thing.
Mr. Naidu, don't interfere.
Mr. Bandyopadhyaya, just wait. You have lung power. I have also equal lung power. Don't try to calm me down. If you are making political speeches, if you are making political speeches, do you expect to be quiet? If you have merit, If you have merit, confine to the matter and impress the honorable court.
Mr. Naidu.
If you have merit, confine to the facts, and you are using even the honorable Supreme Court, where you could not succeed in one instance, and you are making all these tall claims. Please, this is high time somebody call this bogey out. Don't think that you can get away with everything. Don't think you can get away with everything. If
Mr.
it's-
Naidu,
you use every institution, including the courts, to say that one.
You
Please
have lost
confine
this
the
complaint
facts.
for years,
Please
years.
confine to the
I
facts.
don't
If you have
know.
merits, please impress the honorable
Yes,
court.
I am on merit.
Instead of indulging in this character
Unfortunately,
assassination.
you don't understand
And
which is
that
merit and which is not
specialization,
merit.
I don't want to have.
Yes, you don't.
Yes, please, if you have merits, please argue that matter. Calling everybody names, it serves no
Naidu,
purpose.
Mr. Naidu, please let me complete. If
Your lordships have seen, have we uttered even one word extra beyond the brief?
No. Yes.
Don't say extra on the briefs. Don't advise.
Yes.
Yes, don't advise.
Mr. Bandapaja, your frustration is writ large. That shows your
frustration, I can
helplessness.
understand your
That
frustration.
shows your
The power
helplessness.
has been taken.
I
On
only,
your advice,
I
election
only,
commission has
I
done
only,
everything.
I only
understand your
sympathize with
frustration.
you.
I
I only
understand your
sympathize
frustration.
with you.
You are very
Exposed,
sorry, I have to say now.
yes, when exposed, only the rhetoric is your answer. Please go ahead.
Yes, continue.
Now, my lord, everything has gone in from my mind. He is in the habit of disturbing.
You are the senior.
No,
You knows what the opposition.
He was a judge of a high court. See.
Yes.
Now, my lord, public confidence, who will judge? Election Commission will judge. When seriously Election Commission's power has been questioned on number of occasions, and your lordship has seen that the Supreme Court has said serious questions of law has been raised.
Yes.
Now, my lord, see the আর কি ছিল যেন একটা এতক্ষণ বলেছে না এটা রেখে দে দরকার আছে আমার এটা দিস না পরে না এরকম করিস না দিয়ে নিতে নেই দিয়ে নিলে না না এটা দিয়ে নিলে কালীঘাটে সফট কপি দিয়ে নিলে কালীঘাটের কুকুর হয় দিয়ে নিতে নেই there is a proverb in Bengali if you give and if you take then you will be dog of Kalighat. Don't do it. Now, just one.
My dog has the best life.
Yes, I have one German Shepherd. Beautiful. Well, kindly take 2000. এটা কেন দিলে? ওইটা আগেরটা দিতে বললাম তো এটা আগেরটা দেখাতে বললাম তো আরে ভাই তোমরা কেন
কখনই খাবে কিন্তু
নাও জাস্ট আরে ভাই এটা না 84 just 1 minute look just one ওই দোষিস 84 টা দিতে বললাম যেটা তুমি দেখালে যে 1983 দর ভাই তুমি কি পাগল হয়ে গেছো নাকি এই জাজমেন্টটা কোথায় দিলি রে বাবা তুই আমাদের ডিভিশন বেঞ্চে দেবো
আমি দিচ্ছি বলুন না
ডিভিশন বেঞ্চে জাজমেন্ট একটু দে না
হ্যাঁ
পাগল আছে না কি সব আরে তুমি প্লিজ সিট ডাউন just 1 minute AC Jose versus Sivan Pillai 1984 2 SCC 656 par karo
না এটা না
এইমাত্র তো বার করেছিল তো যেখানটা দাগ দিলে সাইডে দাগ আছে তোমাদের দাও দাও আর 84 এটা দাও Lord, can you take this one? Can you take this one? 2024 volume 18 SCC page 643. কোনখানটা কোনখানটা যেন দাগ দিয়েছিলে yes kindly come to me lord yes kindly come to me lord paragraph 37 36 kindly see all judgments have been considered Mohinder Singh Gills, AK just a work. So and so, all judgments have been considered. Right? Now, kindly read below paragraph 37. We would indicate that the restraint self-imposed by the courts as a general principle laid out in some details in some of the decisions. Supra in election matters to the extent that once a notification issued and the election process starts, the Constitutional Court under normal circumstances are loath to interfere is not a contentious issue. But where issues cropped up, including unjust executive action, or an unjust or an attempt to disturb a level playing field between candidates and political parties with no justifiable or intelligible basis, the constitutional courts are required, nay, they are duty bound to step in. The courts have usually maintained so and so.
Yes.
Talking about political, now my lord kindly see that judgment paragraph to work on. Now 1984 2 SCC my lord law Joseph ke dao 84 2 SCC 656 AC Josh Miller spoke about the scope of the writ court. It is I am not stopping an election. Dao Joseph ke dao. Well, I am handing it over. Just I am reading. No.
You give the what is the paragraph?
Paragraph 22. Now you have come with the procedure of law. You have come with the procedure of law. Now how can you commit a breach of that? Now, my lord, kindly see what is the answer. No answer has been given to this paragraph, particular paragraph. I have said so. Where is the petition? Petition. See, what is the answer? Paragraph 16.
Yes.
Except in state of West Bengal, no answer has been given by them. Now, my lord, very recently, they issued an order regarding the, my lord, what has happened in that matter first. The circular I just said, Dennis' judgment. What has happened? They issued a circular, said this 800 pupils, giving all the names of the persons, right from Kuchbihar to Purulia, all are belong to Trinamool Congress. They should be arrested. And High Court has passed an order. They are also, Mr. Naidu short for time for affidavit. First, the court has recorded the Honorable Chief Justice and granted stay. Well, kindly, this is a big order, and your lordships will find that he has said that he is asking for an time to file an affidavit. Time for filing an affidavit is no ground for refusal of an interim order.
Yes.
This is 13, paragraph number 13. The High Court has stayed the order. This is judgment order. Interim order. High Court has stayed this order. Division bench has stayed this order.
WPA?
WPA. Now, my lord, I just very interestingly I tell you, your lordship, WPA P192 of 2026.
190.
192. Now, what has happened, my lord?
Date?
Dated 22nd April 2026. Stayed the order. Now, my lord, what has happened? Thereafter, before 27th April, this election was there. 29th April. 27th April, my lord, they issued another circular giving 4,000 people's names of the All India Trinamool Congress. This election commission in India. How can I have a trust on them? Fortunately, that time the persons were someone's. This time now others. Now, when we urgent mentioning was done, matter was fixed at 2 p.m. 2 p.m. they have come up with a circular, we are withdrawing. Withdrawing we on that day. Bhai, তুমি তোমার পকেটের মধ্যে কি রাখছো আমার দেখার দরকার নেই. Whatever you are keeping on your pocket, I don't. They have shown it in the court. See, on how many occasions I have to come into the court. They are saying how they are coming. And every occasion I have come to the court, I have got the relief. First relief is...
This self-certification leads us nowhere. Let him, Millets, with great respect, confine to the pleadings of the case. He wants to impress upon your lordships, unfortunately, falsely, that every time I've come, I've got the relief. This time also I should. And may I say, Millets, every time he came, he lost. Miserably, he lost. He presents a pathetic picture. And wants to self-glorify himself. He wants to self-glorify himself. He wants to give certificates to himself. Millets, with all your lordships' long experience, Millets, have your lordships seen a rejoinder, a reply argument going on eternally and ad nauseum?
Mr. Chaudhary.
Just 1 minute.
Just because my lords feel that, okay, let him, it goes on.
Well, kindly see, my stand, which was from the initial day to this day, is power of superintendence is there rested with the Election Commission. Directions can be issued by them. If it violates any law made under Article 327, that is bad. When you have let down the procedure, you can't deviate from the procedure. This is the case. Okay. You can't change the procedure. In case of one state, one procedure. Another case is another state. And yes, the power which was telling these replace the people.
No, there's no deviation from procedure. I've shown you a lot.
Mr. Chaudhary,
We get all the material, Millets. We have been uniform in every state. We have not singled out anyone.
What is giving no advice? Where is the
That's why, Millets, they come at the 11th hour so that we cannot show to your lordships.
What is this? Election Commission is perturbed.
Okay.
You will kindly see. You will be more perturbed on 4th. সেকশনটা কত দেখাচ্ছিল জানো? সেকশন গুলো দেখাচ্ছিল না, লিখছিল
100.
No, not 100. 100 is the middle of the election dispute.
Yes.
Regarding the delegation of powers.
That 19A.
19A. Kindly see.
20.
19A. Delegation of functions. The functions of the Election Commission under the Constitution of the Act under the rules are made there as maybe direction of the secretary, not the assistant chief election commissioner who has passed the impugned order. Then see, generally subject to the superintendent, subject to directions, control and election commission, the chief election officer shall supervise the conduct of elections in the states under the act. Supervise the election. That doesn't mean he will lay down the policy decision. This power is vested with the chief election commissioner, election commission, or the persons whose names are there in section 19A.
Yes.
Then we'll have general duties of district election officer. CEO is not the district election officer. Then observers. It is not questioning about any functions of the observers. Counting superintendent is no way it can be equated with the observers.
Yes.
One judgment I am missing, I am remembering, that is 82 or 83. The Supreme Court has said, you see, I'm forgotten just the principle of law I am saying, Miller. You see, if there is a case to pass an interim order, court will pass an interim order. Court will not look into the consequences of that. Question is, Millard, whether I have pointed out any illegalities or not. If I have pointed out illegalities, your lordship will pass the order. If I am not, not.
Okay.
These are the.
Your lordship had a question for me,
Yes.
my lord?
This 13th April, which is under challenge,
Yes.
correct? You have issued on the apprehension. What is the main issue raised by Mr. Banerjee?
Yes, my lord.
So you are also having the apprehension. How it can be?
I'm sorry, I didn't hear the question.
Kindly see the first line. In
Yes.
view of the apprehension.
In view of
expressed from various-
apprehensions expressed from various.
Can I go, my lord? I have to. Incidentally, I have to go to a one returning officer now.
Yes.
A man of field, I know everything. তোর chief election commissioner হচ্ছে ভালো election বুঝে।
তা বুঝবেন তো। Of course.
And you know his client what he say requested me. Dada, you please be a counsel of us. Ask him.
Would have been a better counsel than me for sure.
Okay.
Milord, yes, Milord.
The apprehension
Page
expressed.
27, Milord.
Page
In
27.
view of apprehensions expressed from various quarters regarding possible irregularities during the process of counting of votes,
Correct.
and with a view to ensuring transparency, integrity,
That
and
is
orderly.
that is okay. That is not
Yes,
a problem. So you have issued this order on the apprehension,
yes.
correct? And if
No.
you have issued the apprehension, now you come to the paragraph 16 of the writ petition. Can
Yes.
you have issued the same order to the Assam, Kerala, Tamil Nadu, Pondicherry?
Paragraph 16
Paragraph 16.
is unaware as to whether any similar notification.
These are the two issues which Mr.
Yes.
Banerjee has emphasis on
Yes.
that.
Millets, my instruction is we have done that in Kerala.
Okay.
We have done that one in Kerala, Millets, not singled out any state for that matter. As the situation demands, Millets, we do that one. And also, Millets, my lords, the question is, Millets, the powers of chief electoral officer, and section 20 is loud and clear on that aspect, Millets.
No, that
Section
will-
20. My lords have already taken note of that one. I would like to tell Millets.
But even again, then how the election additional chief electoral officer can come?
Millets,
And
within
come
the
to-
sphere, there are
can you-
delegation of powers,
can you
Millets.
come to the
Within the
19
sphere, there are delegation of powers.
Yeah, can you
And
come to
based on that one, Millets, it is not their case, it is the question of virus, in my humble submission.
Yes, not virus. What he is telling.
Yes,
that-
Millets.
These are the main 3 points Mr. Banerjee has taken into consideration with regard to apprehension, with regard to the other 3 states, and the additional chief electoral officer.
They say, Millets, nobody has the power. 2023, we have put that in the public domain. Para 15
Okay.
plus 9. That these are the powers that could be exercised when the situation demands.
Thank you.
Grateful, Millets, deeply obliged.
Thank you. Thank you.
There's another supplementary.
और किया अच्छा तो समरी नहीं
Yes, yes.
और किया अच्छा एक भी डॉक्यूमेंट इधर ये उनको दे दो पहले एक भी डॉक्यूमेंट इधर उधर जजमेंट इधर उधर नहीं जाना उसमें देखो एक नोट लिखा होगा
Milord, the observer's handbook, Milord. I had
Yes,
brought
you
a
give the
copy. Copy is down. Milord, they have it. We've also, Milord, given them soft copies.
Yes,
But if they give it, I
yes,
can.
what is the next matter?
And the next matter is at the instance.
एक साथ क्यों नहीं निकलता आप लोग का?
Just, Milord, we'll print in.
जब नहीं आया तो क्यों लिस्ट करते हो जब नहीं आया तो क्यों लिस्ट करते हो क्यों मिसलीड करते हो कोर्ट को जब हम दोनों एक साथ दिया एक फाइल है तो एक लिस्ट करना है मेरा बिना दूसरा लिस्ट कैसा हुआ दोनों को हम बोले एक साथ करने के लिए एक फाइल नहीं है तो कैसा लिस्ट हुआ दूसरा मेरे से पूछा साहब को रत instruction, nothing to be done.
Leave was obtained in the morning.
Leave obtained, only one file has come, one list has been published.
My matter is
How
earlier.
the second list has been published without the instruction
But
of
I
the
do
court?
not know, my matter is earlier at point of time.
I don't know.
Kindly see the WP number.
I don't know.
It is not anyone's fault. Maybe the system has listing.
Going
system.
on, I don't know. Yes, what is the matter?
This is at the instance of the candidate belonging to one political party,
What is your prayer, sir?
my prayer is, last moment change of counting venue. Counting venue. This entire law flows from Rule 51.
Where is the order? Where is the impugn
Yes.
order?
Kindly see at page 108. Please.
Yes.
Please see page 108. Convening of meeting in connection with general elections to the West Bengal Legislative Assembly 2026. This is dated 26/4/2026 in pursuance of the directions of the Election Commission of India. And in view of the forthcoming general elections to the West Bengal Legislative Assembly, an urgent meeting with all candidates will be held at 6 p.m. at Gitanjali Stadium, such and such, for the smooth conduct of the electoral process. This is dated 26/4. The date of meeting is 27/4/2026 at 6 p.m. I attend the meeting. On that day, it was orally informed that the previous counting venue, which was there, in Gitanjali Stadium itself, and which has been the counting venue for this particular constituency, Kosba Assembly constituency. This counting venue is likely to be shifted to one, Bihari Lal College, near Alipur. Near Alipur. This was orally informed to us. Thereafter, page from page this document, one document venue for the last previous years 112. In respect of 149 Kosba constituency, the venue has been Gitanjali Stadium all throughout.
No.
Page 112.
Yes, 112.
Page 112, the first constituency. This is in respect of 2021. This is the counting venue, Gitanjali Stadium.
Yes.
Now, this year.
So what is your constituency?
My constituency is 149 Kosba.
114 Kosba. Yes.
Thereafter,
This is earlier.
This was earlier. Then, please see.
Earlier means 2021.
21.
Yes.
Then, what they have done is at P5, page 127. 127.
Yes.
On the 28th of April, they say that notice regarding post-poll scrutiny of Form 17A and other documents, from today it is taking place from 11 a.m. Though leave was obtained from your lordship at 10:30 at Bihari Lal College. Now, the law obliges them two things. Law obliges them, in terms of Rule 51 of the conduct of election rules. Now, please see. Boy. The conduct of election rules. Now, kindly take the trouble to come to Rule 51. Time and place for counting of votes. The returning officer shall, I'm sorry, Milord, extremely sorry. Rule 51.
Yes.
The returning officer shall, at least 1 week before the date or the first of the dates fixed for the poll, appoint the place or places where the counting of votes will be done and the date and time at which the counting will commence, and shall give notice of the same in writing to each candidate or his election agent.
Returning officer at least 1 week before.
Yes.
The date.
In the fact
first of the date.
Yes.
Fixed for the poll appoint. Place.
Now,
places. Yes.
Sorry.
Then.
Lord, in terms of this rule, Lord, they have a what is known as the handbook for candidates of 2023. Lord,
So, but proviso?
Lord, proviso is provided the first part is complied.
Hmm.
Proviso is proviso will come into operation if 51, the first portion is complied. There is a date. Lord, I have specifically pleaded in the writ petition that they have never indicated the counting. We all understood the counting venue. We all understood the counting venue because the previous years, all this time, the counting venue was, some other place, the stadium, Gitanjali Stadium. Now, in terms of this handbook, this is the handbook for candidate. A lot of handbooks have been handed over to your lordship. Kindly sees the handbook for candidate. Kindly takes the trouble to come to 14.5.
Yes.
The returning officer shall, I'm sorry, Milord.
Yes, continue.
At least 1 week before the date fixed for the poll, intimate in writing to each contesting candidate or his/her election agent the date, time and places of counting of votes as per forms prescribed by the Commission for the purpose vide Annexure 18 or Annexure 19. Annexure 18, your lordship will be pleased to find at page 283. This is this is Annexure 18. It is a part of that handbook.
Okay.
It says notice to candidate or their election agents regarding the date, time and place of counting.
Yes.
That is Annexure 19. And Annexure 18 is notice to candidates or their election agents regarding the date, time and place of counting. These two forms has not been issued, as per my instruction. What they are trying to do is, after the election was over, in the light of Annexure P5, because 30th they had convened a meeting. This is a college, a 3-story structure, and they are, we have been told, because my candidate as well as the writ petitioner as well as his election agent was present at Viharilal College today. What happened on instruction, I cannot produce documents or photographs because I'm not supposed to. Now, what is happening is they have stacked the ballot boxes and they have fallen down. And the ballot boxes, these EVM machines some of them have been, in a damaged condition. And they are also contemplating to hold the counting without complying with these rules, without complying with Rule 51. They are contemplating to hold the counting at a 400 square feet room, for how many machines? For how many machines?
317 plus.
317 plus EVM machines, 14 candidates as against their election agents and everyone. And this is as against a stadium where there was an expanse, there was a sufficient area, and the area was 10 times the area earmarked at Viharilal College. It was 4,000 square feet which was earmarked. And all these years, Viharilal College was never in the scene in respect of Kosba. Kosba is a place near this Acropolis Mall. The stadium is just beside the Acropolis Mall. Now they are trying to have it where Mr. Chaudhary often goes, behind Taj Bengal. I don't go. This Viharilal College is beside Taj Bengal. Just to cut it little light.
No, you will go after.
Yes, he'll take me.
I'm telling you, you're going. He will go.
Both of us are going to. He's going to take me.
I don't know whether he will take to you or not.
No, that is obviously there.
Yes.
And the strong room even today is at Gitanjali. The counting is taking place there and without compliance with Rule 51.
Yes. That's
it's a 8 kilometer away from Gitanjali to Viharilal. That is my sum and substance. They have not complied with their own handbook. They have not done it within 7 days. They are doing it just 3 days prior to the election.
Yes.
No, they won't allow counting. That's the motive. Petition after petition.
No, why you are changing?
Why I am changing? Note to down. My lord.
Why all controversy you are creating?
No, previously there were 5 different counting venues.
But whether you follow the rules.
Yes.
51.
I'll give you logic. Give your lordship the logic first.
Not logic. First you said tell me whether you follow the
yes,
51
of course.
and the 51 and the handbook.
His petition shows that I followed Rule 51. 5 different counting venues for 10 assembly constituencies. Now 1 venue. That's the reason, because we have an allied strong room, and that's why the shift. Now, my lord, and it has to be with live streaming, etc. Because this time everything's under, my lord, CCTV surveillance.
No, you had challenged that.
Yes.
You had challenged that there's a tender. You're not there, no? It was came before me that tender was challenged with regard to CCTV.
That perhaps I had the occasion.
Election coming.
No,
I
he
had
was.
the occasion.
Yeah, no. Mr. Bhattacharya.
Oh, Mr. Mukherjee was there.
Yes,
Bhattacharya.
he was there. I was appearing.
No, I
for-
wasn't there.
Mr. Mukherjee was there for the election commission.
Yes.
Yes,
Yeah, but that's not, that tender came before your lordship.
The tender did come.
But tender was called by you.
They are called.
Yes. So, my lord, that's number 1. So this is the administrative reasons. Number 2, my lord, please see paragraph 2. He's a candidate.
You are appearing for election commission?
Yes.
Paragraph?
He's a candidate.
This Naidu is not there. Mr. Naidu is appearing? No. Yes, paragraph?
Paragraph 2, my lord. No, he's there.
Mr. Naidu, you are appearing in the second matter. Unmute.
Yes, Millets. Millets, I was just told about it. I'm just trying to go through that one, Millets.
These
Because
are
this
all,
is surprise, Millets. Your
us,
lordships may appreciate,
after
Millets.
6 notice, we are coming and arguing.
I think we have served them long time.
We
it
need
takes
to talk,
time, my lord,
Millets. We need to talk to the
surveys,
officials,
to
get
we are busy
instructions.
conducting an elections. This is reality, but we don't come and ask for an adjournment or postponement.
Yes, paragraph?
My lord, 2, my lord, he is the candidate. Now, my lord, please have a look at.
Let him show annexure 18. The matter is over. You show annexure 18.
I'll
You
show
have done
what
it.
I have to show.
And I know what you can't show.
I'll show what I have to show, and you can carry on. My lord, please see, my lord, paragraph 9. I'm sorry, my lord, he got notice that he is admitted. Paragraph 7. An urgent meeting of candidates called on 27th April. My lord, the notice is annexure P2.
Yes,
Please.
admitted.
Yes.
P2.
So, my lord, candidates were informed.
Correct.
And I'm sure, my lord, other notices must have also gone out. So he was informed of the change. He attended the meeting and he says so. Next page. Paragraph 8. Petitioner states that the petitioner duly attended the meeting on the scheduled date and time when the petitioner was verbally informed that the venue for the counting has been shifted to Viarilal College, Alipur from Gitanjali Stadium, Koshba.
Yes.
He knew he's attended. And if possible, my lord, I'll take instructions. I'm sure they would have informed Mr. Naidu also, whether, my lord, separate notices have gone. But he was informed. Now, my lord, see Rule 51.
The only apprehension was that, Millets, it was 8 kilometers away. Millets, we assure him that all the logistical aspects would be taken care of. Every security measure is put in place. And then, Millets, for various reasons, we have been taking these steps with regard to that one. If my lords feel that it should be looked into, give us time, Millets. We'll place every material and also the justification.
Consolidation of counting. 10 centers, my lord, now rolled into 1. Everything will be criticized.
10 centers.
My lord, we will not be able to, my lord. Today we are on a Thursday afternoon. My lord, if it's serious, your lordship may always, my lord, pass orders, my lord. That's your lordship's jurisdiction. But, my lord, if it's, my lord, on apprehension, issue is tomorrow is 1st May, a holiday. On all of this, whoever is discharging functions, my lord, they have to be given training. Any order, my lord, will have the effect of, my lord, stopping counting on the 4th, which seems to be the motive.
Okay.
Matter after matter.
Lot
You
of
who will
logistical
count,
issues.
my lord, Trinamool Congress will decide who will count. They will decide where the counting will happen. They will decide who will observe the counting.
Okay.
And
And
the
no
Election
material.
Commission is not going to comply with their own law. their
rule-
own handbook.
No,
My lord,
rule-
let him, my lord, I would have
Hey,
gone out
what
of
is-
court. I would have gone out of court if Form 18 was shown to your lordship. Let him show Form 18. Let him show that I was a candidate and I was informed 7 days prior to the date of election.
No, the
29th
proviso
was
lordship
election.
has seen.
Proviso comes, my lord, provided 51 is acted. Proviso comes later. First is 51 act. My lord,
Proviso is always with great respect, Miller. It's an exception. That is the purpose of proviso. When exigent circumstances
did
are
not
there,
Mr.
even the
Naidu.
residuary power can be used.
Liquidity that I have for him, I will request him to kindly hold his breath for some time. My lord, let him show Rule 51 compliance and handbook compliance. My lord, I go out of court.
Okay, you give the copy of the handbook.
My lord, yes. My lord, I have handed over.
You have handed
I
over.
will give you a,
Okay.
I'll give you a
Yes.
lordship.
Anything further?
Yes, my lord, I'll just.
And my lord, just another thing.
Yes.
Insofar as consolidation, my lord, I have indicated in the writ petition 112 is one document, 119 is the other document. Previous all elections, my lord, insofar as Cosba Assembly constituency, the counting venue always had been, my lord, Gitanjali, and no other, my lord, constituencies counting used to take place there. It is only Gitanjali Stadium and
Yes, you choose where counting will happen.
no, it is.
My lord, please see, my lord.
Choice.
Please see Rule 51.
Yes, 51.
Especially the proviso minutes.
Yes. The returning officer shall at least 1 week before the date or the first of the dates fixed for the poll appoint the place or places where the counting of votes will be done and the date and time at which the counting will commence and give notice of the same in writing to each candidate or his election agent. Then below the proviso, provided that if for any reason the returning officer finds it necessary to do so, he may alter the date, time, and place or places so fixed, or any of them, after giving notice of the same in writing to each candidate. So, my lord, he's been given notice, he's attended, he said he's attended, and he's been told. Maybe separate notices have also gone out to those who have not come. He's admitted that he's been told.
Yes. That's all.
Lord, absolutely. And Lord, I don't want to, Lord, yes, Lord, please see paragraph 6 also. Whimsically changing the counting center.
Yes.
So, my lord, according to him, there was a counting center which was nominated. Then, my lord, this is paragraph 6, paragraph 7. By this notice, respondent number 8 called for an urgent meeting on 27th April and changed. That's paragraph 8. So, my lord, this is Rule 51 compliance. Originally at the stadium, then notice, then change. There is no anomaly.
Where is the original stadium? That's why that is their contention. Where is the
My lord, please
original?
have a look at paragraph 6.
No, the paragraph 6 is earlier. His contention was the earlier all times it was in the stadium. Now you have issued the notice. You have stated that that will same in the same place, but all of a sudden you have issued.
No, my lord, please see paragraph 6.
Yes.
Petitioner states that your petitioner has been constrained to approach this court challenging the arbitrary act of the respondent number 1 of whimsically changing the counting center.
Correct. That's
So, my
why-
lord, that's the case.
That's why
So change.
he has made out a case. He has made out a case every time Kasbah was in the stadium, counting was in a stadium, and on that day you also issued the notice, and he appeared in the meeting, and it was informed that yes, your counting station will remain in the stadium, but you have so all of a sudden on 28th of April you have issued this notice fixing the counting station at counting place at the other place, and you have not complied with the provisions of the handbook.
So now his case is that there was no original fixation of place. So the first part is breached. So within 7 days, you can't fix a place for counting.
Yeah, that is the case
So
he
then-
made out.
So that is the case he wants to. It's not possible. He's served now. Now, so therefore, no counting. So what is the argument then? So what will happen?
His case is that why he's not asking for the stay of the counting. Why the counting remain in the stadium?
So
That
let us, my lord, see the prayer made. Let us see the prayer made.
Yes.
I have sent my learned friend to find out whether there was an original area indicated, original place. My lord, please see the prayer. Writ of or in the nature of mandamus, directing, commanding the respondents to withdraw, rescind, cancel, forbear, giving any effect to any order or notification issued by them to change the counting center. So he comes to court and argues that there is no original counting center.
That's why, because that's why he's telling that on the meeting it was informed that since beginning it was in the stadium, so he will remain in the stadium. That is the
No. So he came and that's what your lordship, my lord, appreciated. He came and said, first part of 51 is not complied with. So there was no original, my lord, venue fixed. That's his argument. So he can have one argument. His argument is.
No, he's telling that in the meeting, once he already stated that it is since beginning it is going in the stadium.
Yes.
Correct. It is going in the stadium.
Yes.
So nothing.
So why are you changing?
Yes.
That's his case.
That is case.
So proviso to rule 51 allows me to change. I'm changing.
Okay.
And the reason is consolidation. No, it's there. They're not saying that. So once let's Milord be sure of the facts, Milord. He says you fixed Gitanjali Stadium. Then you shifted on the 27th. You shifted it from Gitanjali to Alipur. You could not have done so. This is his case. If this is his case, Rule 51 is my answer. Milord, please, Milord, see.
That's why I put the question to him, proviso.
Milord, for a moment,
Besides that also.
I thought his case was that no original place had been fixed because he was speaking, my lord, in two voices.
Yes.
But now that he agrees that an original place is fixed, he wants the change not to happen. Answer is, my lord, Rule 51 says, provided that if for any reason the returning officer finds it necessary, he may alter upon giving notice. Now, why do I find it necessary? I find it necessary because there were 5 different counting venues. I am consolidating 5 different counting venues into one venue. So 10 assembly constituencies votes will now be counted at one venue. The advantage of doing so is it is easier for me to ensure, my lord, CCTV coverage because that's, my lord, we are doing it for everything, these elections. Number 2, it is easier to monitor. It is a very, no matter how much we come here and
how many counting station in the stadium?
10 assembly constituencies had 5 counting venues.
How many counting stations are there? Counting places are there?
5
total.
No. Last time for
Not
10.
last time. This time, how many counting stations?
For
are
10, 1.
Total,
So, my lord, 10.
Total, how many?
Total in all of West Bengal.
Yeah.
In Calcutta.
It is a Calcutta.
In Calcutta. Call up, find out.
So that's why you are giving the biodata.
No. For I asked.
You have given the 10. So how many counting?
So no. I am saying 10 assembly constituencies. For these 10, we are now going to have one venue. So the number, my lord, I'll just find out.
So
find out now.
Yeah, may I?
Notification है जिसमें specifically बोले दिए जो only educational institution and colleges would be used. तो देखिए.
Yes, my lord. There's also a notification that Commission has instructed that counting centers should be located at district headquarters or in exceptional case at subdivisional headquarters. Further, so far as practicable, government buildings other than colleges, education institutions are to be registered, keeping in view suitability to establish counting center. So, my lord, it also has to be, my lord, there has to be some proximity to headquarters. In fact, that was what, my lord, the DM had also said.
Instruction in the print. There, you're not a print.
Milord,
You are
they are all
taking-
coming just now, Milord.
Take the
I will
print
just
and
get a
give
print.
the
Go
court.
get a print.
If I will pass an order, then you will go to the appellate court. See, my lord has not considered.
Milord,
That is the
no,
problem
Milord,
with all of you.
I know, Milord, I know.
All the
but
two matters you have done
please-
this like this only.
But please, Milord,
When this court has given 3 times, you are not submitted, and you went to the appellate court. My lord, see, this is the notification not considered. This is a notification not considered. And now the same thing you are doing here also.
Milord,
See, Mr. Naidu is appearing from the Delhi, but he is having all the documents. Why you persons are not bringing all the documents? I don't know. 2 matters you have done all these things. On one day, I already Mrs. Pandey, I have already directed her. But they're not bringing mobile phone. You can read it. If you are having give the document to this
Sir,
court.
when I have got it, Lordship will see, Milord.
If you said that you are not ready, then not to argue.
And allow an order to be
What
passed.
can be done then? If you are not placing the document, you
But I have just got
on
it
your
right
own
now.
on your own mobile phone, you are reading
Go
and
get
keeping
it
within your
printed,
pocket.
go get
How
it
the court
printed.
can do? Court has to send document.
Milord, I am getting it, Milord. Its Lordship will appreciate. When, Milord, the petition.
1 hour you had a time, you are not collected that.
Milord, we are asking, Lordship will also appreciate the persons who give us instructions also have some other work. To get them to go to the file, take it out, send it to us. Milord, we are trying our best. Milord, this is the difficulty. Lordship will, Milord, please consider. This is the difficulty we face. We are trying our best.
You are doing the last hours to what the litigants also do. Kindly see when the order was issued.
28.
Then what the litigants do? Litigants said only the last hope of the
29th was
court.
election.
Milord, this is
Today
not,
is
Milord,
30th.
a litigant whose rights are, Milord, being infringed.
That the court will see.
Everything,
you
Milord.
can argue the matter, but the court will see whether right has been infringed or not. It is up to the court. You can only submit.
Milord, am I trying to do more?
Yes. Now what you're telling? It is not the infringing.
No, he is, Milord. The sitting, Milord, please see paragraph 2.
My
What?
only
So what?
is-
Is it recent title?
my only anxiety is that once you are making all the submission with regard to the data, you have to come with the document so that the court can record all these things.
Milord, I am trying my best to do that. And the commission is also, Milord, trying their best to, Milord, send us the papers.
Yes.
Milord, if we've sent for a print, it will go to Old Post Office Street, Milord, get it and come back. Milord, this is the difficult. She appreciates our problems also. Milord, service is service in
Yes,
the
Mr. Naidu,
afternoon.
what is your submission?
Ki darkar.
Because the court cannot pass any order without the document on verbal, and verbal can be changed at any point of time. And this court has faced, that I am telling. This court faced.
Which is why, Milord, if your Lordship will, Milord, please consider.
Appear twice, 3 dates has been given, third advocate on third day, and make some other submission and filing an appeal and making
No, your
other
Lordship
submission.
will also appreciate, which is why the genesis of the law that elections are not to be stopped or interfered with.
I think he is, Milord, completely, Milord, flown at a tangent to the actual matter.
My only question
My
is
only-
that
No, I am trying my best to answer the question.
I appreciate that, yes, with regard to this, you have to show what decision you have been taken. Because all
So
the
to
things,
get,
all the things.
Milord, also, Milord, please appreciate.
When you receive the writ petition,
When I receive
Your
the writ
office,
petition,
your
please
office.
show the email, it goes to the commission. And when we are moving,
At 12:27
12:27,
Milord,
2
he was
o'clock.
absent at 12.
Yes, 2 o'clock, we are before your Lordship. So, Milord, it's less than 1.5 hours to photocopy, scan, send it for instruction. And from 2, I am before your Lordship.
Okay.
Exactly 80 minutes.
Okay. Anything further?
No, Milord, it's. But if your Lordship will please, Milord, consider that it's for administrative, Milord, reasons. I have asked the DM, he told me, Milord, that we are consolidating 10 assembly constituencies in one venue.
Give in writing, 4-line instruction, give in writing. Give in writing.
Give us time to find it.
My lord,
by
I think he is
5
not properly instructed.
That's
My lord.
good.
Milord, I am
Very
told,
well, my lord, it is only one constituency which is going on.
Milord, I have
So many, how many constituency has been given to this school premises?
Bihari Lal.
Bihari Lal school premises, how many constituency has been given for counting?
just call this person. কোথায় পাঠালে তুমি?
Lord, these are the relevant portions of the handbook.
Calcutta North has 7 seats, counting venue. South has 4 seats, 4 counting venue.
God knows. Huh.
DM doesn't know about the Calcutta. He knows
No,
about
no.
the-
DM South 24 Parganas. Call DM South 24 Parganas, ask him.
Okay,
I spoke to the DM South 24
do one thing.
Parganas
You
and I
do
wrote
one-
down in my hand this.
Whatever it is, what your instruction, give to my court officer, I will.
Right.
Yes.
And my instructions
Three
stand.
things, why, what is the reason for transfer? First thing. Second thing, how many constitution has been given, constituency has been fixed for the counting in this said college, and whether it's prior to that any station, any counting place has been fixed.
7 days. My lord, rule 1819.
The proviso says it's possible.
That I understand.
But your lordship wants to know why have you done so. So I'll tell your lordship the why. Now that your lordship has given me, my lord,
now you
at least 45 minutes, I'll get it done. My lord, I had
45 minutes.
Yes, it's 4:15.
Ah.
My lordship said 5. Give it by 5 to my court
Not
officer.
put you to my court officer. Okay, give whatever.
5:10, my lord. With half an hour, 45 minutes, my lord.
share
I'll
it
give
with
you.
me also.
Why?
You'll not share it with me.
Yes, you give the copy to them also.
Strange. Mr. Chaudhary, we all know.
No, my
The
lord.
regard that I have for you.
No, my lord.
Please.
This is I'll just obtain a letter from the election commission indicating this, addressed to the advocate in the form of an instructions, and I'll give it. Then I can give my learned
Yes,
friend.
that's right.
Otherwise, it is difficult to give an
That's
official
right. But
document.
I am not asking anything further.
But my lord, my request is, counting is on the 4th. Anything, my lord, we won't be able to count. Elections can't be declared. Results can't be declared. Please, my lord,
Why you
consider.
apprehending?
No, my lord,
They are apprehending only why your lordship, my lord, kindly.
we want to close
because
it.
they know it that they have not
So
complied
lakhs
with
of-
Rule
no,
51, Part 1.
Please understand, there are a large number of people have worked tirelessly for this process.
Free and fair election.
Correct. Where over 90% people have voted for the first time.
No, let us not go into these figures. Previous election, 85% people voted.
Please don't.
My lord, the
Let us
learned
take
advocate
matter.
general had, my lord, indicated, my lord,
Already made a statement, Millets, that it not going to come up. Millets, I'm only tendering replies in 114, 159 and 150.
Which one?
This is the batch of matter, Millets. The West Bengal revocation batch matter fixed at 2
Acha,
o'clock.
batch matter. कौन सा item number?
159 and 160.
my lord, it's 145 to 158 altogether. The learned advocate general mentioned the matter at 2 p.m. my lord. 161 only.
Yes. अरे आइटम नंबर बताइए ना फिक्स वाला आपको कॉस्ट लिस्ट ढूंढने में भी इतना टाइम लगता $145 to $158. How many? In which matter you are filing?
159 and 160 Millets, I'm filing my reply.
And
Yes.
Your Lordship, this is the
This is also
there
Millets.
is an opposition in the same.
Just a minute.
Sorry, Your Lordship.
Yes,
In which
Millets.
matter you are filing the
159 and 160 Millets.
159
and 160 Millets.
Two
matters.
only
Yes,
two.
Millets. Yes, Millets.
You are for the
Millets, I'm for the petitioner, Millets.
Huh?
I'm for the petitioners.
counsel for the writ petitioner has filed affidavit in reply in connection with WPA 13176 of 2025 and WPA 16746 of 2025 Let the same be kept with the record. Yes, what you are filing?
Jeez, Your Lordship, it was in the same matter, just the affidavit in opposition
Appearing for?
for R2 and R3, for the state and WBIDC, in the same matters.
The Land Council for the restaurant number 1 and restaurant number 2 file affidavit in opposition. Petitioner file reply. Let the same be kept with the record. Police. As the matter is specifically fixed today at 2 p.m. but due to paucity of time, the matter could not be taken up for hearing. Let the matter appear on
Yes, may I request for a date anytime after 14th, if my lord permits.
14th?
14th of May, Milas, for the last week, if possible, Milas.
Let the
I
matter
understand others
appear.
may also be filing the replies.
Let the matter appear on 8 June at 8 July at 2 p.m. 8 July 2 p.m.
Malad, in the meantime, whatever affidavits are left, Malad, if
You
that
file it. Already there is an order.
Milas, 10 to 13 is the original side matter on the same question, Milas. Same question may also
Malad, in
Milas,
the
come up
original,
with the only Milas.
Okay,
Malad, in the original side, Malad, item number 11, Malad, I'm appearing for the petitioner, Malad. We have concluded our submissions, Malad. The interim order is expiring today, Malad. May that only be extended. That's my limited prayer, Your Lordship.
अच्छा उनका क्या मैटर उनका कौन सा है 76 what has happened you had been to the any report has come here कोई report आया है 76 में देखो report आया 76 में देखिए report आया उसमें क्यों देख रहे हो 76 में देखिए ना whether any report has come no report has come हाँ अरे हम पूछा कोई रिपोर्ट आया आप लोग तो कोई फाइल खोल के देखते नहीं ना सर record and order though the matter is fixed today as item number 76 but no report is filed accordingly but there is no report that's क्या बोला but the matter could by an order dated 3rd of March 2026 this court directed the committee to submit the report but no report has been submitted accordingly the committee is directed to submit the report when June let the committee is directed to submit the report by 7th of May 2026 This is the matter on 7th of May 2026 for filing report by the committee. The department is directed to communicate this order to the committee for compliance. 10th is Sunday. After 10th, the court is not here. Then it will be after vacation.
May I have Lordship to mention the original side item number 2, Lordship.
Huh?
Is he given copies of the report?
Let the court supply. Let the report come. Yes, 7th you come, it will be taken. इसको top में रखना है. 7th में come at 11 o'clock. 10:30. At the top. At the top. At the top. Yes, next.
Original side matter.
Not you keep whatever you keep with you. Let's come on 7th. Let the report be for come. Then we'll see to that.
Original side.
Judgment.
Item number 2, Your Lordship, the original side interim order.
Let the staff change.
I thought he was coming, so I thought.
Appellate side matter, my lord, may I be permitted to mention, my lord?
Who is senior? Who is senior? Who is senior? He is senior or you are senior?
Mine is original side. His appellate side.
Appellate side is over. Now appellate side.
Only one thing, my lord, may I indicate?
Yes, what is the matter? What?
Lordship, the item number 2 to be mentioned, Your Lordship. Interim order is expiring on 4th, Your Lordship. Lordship, I mentioned on the last day.
Number 2, it will be called.
Lordship.
What is the urgency?
No.
So?
I thought Your Lordship will.
1-1.
0. Today list, my lord.
Who is for the other side?
Served, my lord.
Record and order. Though the matter is listed as item number 112, but due to paucity of time, matter could not be taken up for hearing. So counsel for the petition mentioned the matter and submitted the interim order still today and paid for extension of interim order. In view of the above, interim order is extended till 25th of June 2026 or until further order, whichever is earlier. Let the matter remain in the list. Yes, call the list.
May I have my lords kindly to only mention, my lord, item number 11 of the original side list, my lord. It's another revocation writ petition, my lord. Interim order expiring today, my lord.
Let.
Very well.
Yes,
Very well. Very well.
Call. The plaintiff is entitled to get an amount of rupees 1,87,99,874 along with the interest at the rate of 10% per annum from the date of filing of the suit till the realization of it. Next. Yes.
My apologies, Your Lordship. Item number 2, Your Lordship. Interim order expiring on 4th. I mentioned it on the last occasion. Lordship was pleased to direct them to give.
Who is your further respondent?
Defendants 13 and 14, Your Lordship.
Your any objection?
I don't have any objection to that.
Give the. The matter is listed as to be mentioned on the prayer made by the counsel for the plaintiff. On the ground that plaintiff, full stop. Counsel for the plaintiff submitted the interim order till 4th of May 2026 and prayed for extension of interim order. In view of the submission made by the counsel for the plaintiff, the interim order is extended till 25th of June 2026 or until further order, whichever is, let the matter remain in the list.
Any time?
No time. When the time is fixed, you are not coming, then no time. वो तो नहीं है, वो तो टाइम ले लिया, आराम से जाने दो. जो टाइम डेट फिक्स रहता, taking time, normal date, no time further. Yes, next.
I appear for the bank in this matter, Lordship.
The same matter.
Yes, my lord. IDBI matters, my lord.
Let all the matters appeared on कब देखा था date? 8th July.
Time may be fixed,
8
my
July,
lord.
3 p.m.
My lord, the time may be fixed, my lord. The bank is suffering in order, my lord.
3 p.m.
My lord, 8 and 9, my lord, I had completed my argument. The learned, my lord, senior advocate for the Union of India was supposed to start, but my lord, today
8 and 9. So the matter is specifically fixed today at 3:45 p.m. But due to paucity of time, matter could not be taken up. According cases adjourned. Let the matter appear. Give the month of June में क्या है?
Learned advocate Amrita Pandey is there.
Huh?
Learned advocate on record Amrita Pandey is there virtually, Your Lordship. 8 or 9.
18th June at 3:45 p.m.
very grateful, my lord.
Next.
List 10 to 13 are the same matters on revocation of incentive scheme.
My lord, I appear for the petition on item number 11.
इससे पहले क्या था फिर?
That's on the appellate side.
That was on the appellate side, my lords. 140.
अभी ये जो कौन सा है? 3 बजे वाला? नहीं मतलब? अभी फिर 3:45 किसको दिया? वो 3 PM. अभी 3 PM किसी को दिया ना? वो तो इसमें आना चाहिए. नहीं दिया ना? पक्का? Yes. Item number?
List 10 to 13 are also millards in the
10
original
to
side.
13. Let the matter appear on 8th of July.
Same date.
8th of July.
My lord, in item number 11, my lord, there's an interim order subsisting, my lord. That may only, my lord, be extended, my lord, till the returnable date.
8th of July at 3 PM.
At 3 PM.
8th of July, 3 PM. It is submitted by the learned counsel for the plaintiff in WPO number 572 of 2025 that the interim order is till today.
Yes, my lord, till
Today and a prayed for extension of interim order. In view of the submission made by the counsel for the plaintiff, interim order is extended till the next date of hearing or until further order, whichever is earlier. Next.
I'm deeply obliged, my lord. I'm deeply obliged.
हो गया? है ना? फाइल्स ध्यान रखो ना, चैम्बर में लेके आना है.